Hello. Hello. Krishnasamy. 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 ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಅಲ್ಲ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಹಾ ಇವಾಗ ಬರ್ತಾ ಇದೆ ಇವಾಗ. ಕ್ಲಿಯರ್ ಆಗಿಲ್ಲ. ಹೇಗಿದ್ದಾರೆ ಲಾರ್ಡ್ ವೆಂಕಟೇಶ್?
ಸರ್ ಕೋಟಲ್ 16 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಹಾ ಕೇಳಿಸ್ತಾ ಇದೆ
ಸರ್. ಇವತ್ತು ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇದೆ, ಸೊ ಹಾಗಾಗಿ ಕೇಸಲ್ಲಿ ಕಾಲ್ ಔಟ್ ಮಾಡೋ ಅಂತ ಅಡ್ವೊಕೇಟ್ ಮಾತ್ರ ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲದೆ ಇರೋರು ಬೇಡಿ, ಮ್ಯೂಟ್ ಮಾಡಿ ಇಟ್ಕೊಂಡಿರಿ. ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ ಇದೆ ಕೋರ್ಟಲ್.
ಅಲ್ಲ ನಾವೆಲ್ಲ ಮ್ಯೂಟೇ ಮಾಡಿರ್ತೀವಿ, ಜಡ್ಜ್ ಅನ್ಮ್ಯೂಟ್ ಅನ್ನೋವರೆಗೂ ಅಲ್ಲೇ.
ಇಲ್ಲ, ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಏನಾದ್ರು ಬಂದ್ರೆ ಅದು ಜಗತ್ ಜಾಹೀರ್ ಆಗ್ತಾ ಇರ್ತದೆ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಡೈಲಿ ರೆಕಾರ್ಡ್ ಆಗ್ತಾನೆ ಇದೆ.
ಹೌದಾ?
ಇವತ್ತು ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ದೀರಿ, ಇವತ್ತು ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ದೀರಿ.
ನಮ್ ಕೋರ್ಟಿಂದ
ನೆನ್ನೆ ಕೂಡ ಇತ್ತು, ನೆನ್ನೆ ಮೊನ್ನೆ ಇತ್ತು.
ಹೌದಾ? ನಮ್ ಕೋರ್ಟಿಂದ ಇವತ್ತು
ಇಲ್ಲ ಇಲ್ಲ, ನೆನ್ನೆ ಮೊನ್ನೆ ಇತ್ತು.
ಕೋರ್ಟ್ ಆಫ್ ಸರ್. ಸರ್ ಹೇಳಿ.
ಮೆನ್ಷನ್ ಮಾಡ್ಬೋದಲ್ಲ?
ಮಾಡಿ ಸರ್, ಮಾಡಿ ಸರ್.
ಮೆಸೇಜ್ ಕಳ್ಸಿಲ್ಲ ಕಣೋ. ಏ ವಿಜಯ್, ಮೆಸೇಜ್ ಕಳ್ಸಿಲ್ಲ.
ಸರ್ ನಾಗರಾಜ್ ಸರ್, ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
ಓ ಸಾರಿ ಸಾರಿ.
Submission, my lord.
Page-wise adjournment. Admissions ಎಲ್ಲ ಮುಗಿತು. That's what that. See, instead of calling all the matter at a one straight, I say that urgent that. Amal, I can take regular matter. Everybody is saying that do this, that this, connected this. See, connect ಮಾಡ್ಸೋದಾದ್ರು after the process, you can connect that matter. Our file ಮಾಡಿದಾರೆ, our ಹೆಸರು ತೋರಿಸಿ, ಅವೆಲ್ಲ you can do it later. There are 2000 matters simply pending in that office. Yes. Wait, we'll call the list first. You want posting? Posting, you give that, they will take that one.
Yes, Monday they will take.
Page-wise adjustment. Page number 1, serial number 1 and 2. Page number 2, serial number 3 to 6. Page number 3, serial number 7 to 9. Page number 4, serial number 9 to 13. Page number 5, serial number 14 to 20. Page number 6, serial number 21 to 25. Page number 7, serial number 26 to 30. Page number 8, serial number 31 to 38. Page number 9, serial number 39 to 45. Page number 10, serial number 46 to 51. Page number 11, serial number 52 to 61.
Okay. Serial number 60, my lord. Press 3 this time, my lord. Happy man.
Which one serial number?
60, my lord. 0.
61, Lingaraj HS.
60, my lord. 60.
Abhijit ML.
Yes, my lord. 3 weeks time, my lord.
Yes, MF. At the request of council for appellant. 3 weeks. Yes.
Page number 12, serial number 62 and 63. Page number 13, serial number 64 to 69.
Lordship, in this matter, Lordship, my lord,
Request of council for respondent number 1. Release this matter. 2 weeks.
my lord,
Yes.
serial number 68, Lordship, I am for respondent. I inform to other side, Roshvendra Swami. Lordship, kindly grant me 2 weeks time, personal inconvenience, my lord.
The request of respondent number 1 to 3. Release this matter of 2 weeks.
Much okay.
67, my lord. 67, my lord.
Yes, your appeal, sir. At the request of respondent number 1 and 2 weeks. Yes.
67, my lord. 67.
Yes, Umesh.
Weeks time, my lord. 67. I'll look into the records and next week I'll make.
For appellant. Release this matter next week.
Public.
Page number 14, serial number 70.
Yes, yes.
Serial number 1, Malakshaya for appellant.
No, that she is appearing for no. Radha, I think she is also appearing PSRTC.
Sir, live streaming ಅಲ್ಲಿ ಇದ್ದೀರಾ, ಮೈಕ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
Then we'll all this matter along with that division bench. It has to go before. Then it has to go before the division bench. The council for the appellant has submitted that the appeal filed by the claimant arising out of the same judgment and award is pending before the division bench in MFA. My number kodi. Post this matter along with so and so before the division bench after obtaining necessary order from the chief justice.
Serial number 2.
Check ಮಾಡಿ ನಂಬರ್ ಯಾವುದು ಅಂತ ಇನ್ನೊಂದು ಅಪೀಲ್ ನಂಬರ್ ಯಾವುದು ಅಂತ ನೋಡ್ಬಿಡ್ತಾರೆ. Balraju, week's time is granted to do the needful.
My lord, I am for the appellant, my lord.
Yes.
My lord, this matter is connected with MFA 1688/18 filed by the claimant. If that matter is connected, my lord, there is no question of taking steps to other side.
Who-
And my
who
lord,
is that?
we have deposited a sum of rupees 10,94,582
Mr.
before the tribunal, my lord.
Who is that counsel who is appearing in that matter?
Kumara KG.
Yes.
Kumara KG.
Permanent counsel for the appellant has suppressed that. The claimant has also filed an appeal by one counsel Kumar KG. He may be directed to take notice for respondent number 1 to 3. What about 4? 4 ಸರ್ವಾಗಿದೆ. Yes.
ಸರ್ವಾಗಿದೆ. Connect post along with MFA 1688/18.
So and so name. And post this matter along with that so and so.
ಸರ್ ನಂಬರ್ ರಿಪೀಟ್ ಮಾಡಿ ಸರ್ ಇನ್ನೊಂದ್ಸಲ.
1688 of 2018.
Lord, I appeal for appellant in this case, Lord.
Yes.
Lord, so far as issuance of notice to R1, I'll file memo in the office, Lord. Notice to R1 may kindly be dispensed with, Lord, owner of the vehicle.
Permanent counsel appearing for the appellant. To VC has submitted that notice to respondent number 1 may be dispensed at the risk of the appellant. To that effect, he will file a memo in the registry.
Please, Lord.
Submission of counsel for appellant is taken on record. The above taken on the memo submission is taken on record. Notice to respondent number 1 is dispensed at the risk of the appellant.
Please, Lord.
For having served copy to R2.
I'll-
Have you served the copy to that? Krishna
No, my
Kishore?
Lord, I'll serve, my Lord. Grant me a week's time, my Lord, I'll serve.
Gurudev Prasad.
Yes. Yes, Mr. What is this for? There is no dispute regarding the liability. Where is she? Non-depositing of 50%. Pass her. If she is ready, we'll hear. Otherwise, we'll have to. Furnishing of deposit fee of 10 issue notice to the R1 and R2. Each time is granted to do the needful.
Connected, my lord. I appear for the appellant in the connected matter. R1, I think, is the insurance company, my lord. I'll take.
What about R2?
R2 ಅವ್ರ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹಾಕಿದಾರೆ ಈಗಾಗಲೇ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು.
Mesh.
In my case, my lord, yes, my lord, I'm here.
Directed to
But
take.
in my case, I will have to take steps, my lord. I have taken steps for the same address. Strangely, my lord, it has come with the endorsement saying that a number is not correct. The same, my lord, whatever they had given before the tribunal, same address I have given. Anyway, I will take substitute service as far as auto is concerned because of liability. As far as the other case, my lord, I'll take notice.
Yes. 7, serial number 7. She, P.S. Umesh is directed to take notice for respondent number 1. Office is directed to show his name. 7.1. Permanent counsel for the appellant has faced weeks time to do the needful.
Copy, sir, ಮಾಡ್ಬೇಕು.
Copy ಕೊಡಿ ಶ್ಯಾಮಣ್ಣ ಅವರಿಗೆ. Yes.
Public.
Yes, Satish Chandra, non-furnishing of PF issue notice to respondent number 1. Weeks time is granted to do the needful. Furnishing of PF. Yes, Mr. Vijay Kumar. Weeks time is granted to do the needful. Same. Non-compliance of office subjects based on so and so. 1. Weeks time is granted to comply the office objection.
My lord, in this matter, respondent number 2 has been served.
Yes.
The Shara says that it is unclaimed. It may be treated as served, my lord.
Is there any dispute regarding that liability?
Yes, my lord, the claim petition has been dismissed. On behalf of the insurance company, Pradeep B appears, my lord. Respondent number 1 is an insurance company. And R2 is the owner, my lord.
Notice issued to respondent number 2, written with postal shara that unclaimed. Hence, notice to respondent number 2 is held sufficient. Heard, admit.
Much obliged.
Yes. Week's time is granted to do the needful. Yes, Mr. Ravi. Yes, Ravi. Yes, week's time is granted to do the needful. The net counsel for the appellant has filed a memo seeking dispensation of service of notice to R3. Memo is taken on record. Service of notice to R3 is dispensed at the risk of the appellant. Yes, next week. ಯಾರಿದ್ದಾರೆ? Pradeep is served unrepresented. D. Pradeep is directed to take notice for respondent number 2. The net counsel for the appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed at the risk of the appellant. Yes, you serve a copy. Ready, Mr. Ravi? Yes. Learned counsel for appellant has filed a memo seeking dispensation of service of notice to R1 and R2. Memo is taken on record. Service of notice to R1 and R2 is dispensed at the risk of the appellant. Yes. 2006. No, what is his age? Yes. As the examine the doctor. ಸಿಗ್ನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಅಲ್ಲ ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ತಗೊಂಡಿದ್ದಾರಾ ಎಷ್ಟು ಅವ್ರ ಕ್ಲೈಮ್ ನೋಡಿದ್ದಾರೆ ಇನ್ಕಮ್ ನಲ್ಲಿ 15,000. What about that other this thing? Pain and suffering ಕೊಟ್ಟಿದ್ದಾರೆ loss of income during the later period. Yes. He was 13 days. Father was hospital Bangalore. Yes. For food and nourishment, 10,000 award. Conveyance charges 9,000 award. Yes. But the loss of amenities, only 10,000. Yes, that's all. See.
ಸರ್ ವಿಜಯ್ ಕುಮಾರ್ ಸರ್ ಮೈಕ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ
sorry,
ಲೈವ್
sorry.
ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ
See, Ravi Kumar NR, Cabinet Council appearing for Climate has contended that at the time of the accident, he was earning 15,000 per month. The tribunal has assessed notional income of the Climate as 9,000 per month is on lower side. He further contended that due to that accident, the Climate has suffered grievous injury. He was inpatient for a period of 13 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, and other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri Reddy Learned Counsel appearing for insurance company has contended that even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Considering that, therefore, the tribunal has rightly assessed the notional income of the claimant as 9,000 per month. He further contended that the injuries suffered by the claimant are minor in nature. He was inpatient only for a period of 13 days. Considering that evidence of doctor and considering the wound certificate, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There is judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 29/2/2016 due to rash and negligent driving of driver of Mahindra Maxima vehicle bearing registration number KA18 A6728. Due to that accident, the claimant has suffered the following injury. He has examined the doctor CW1 Ronald Menzins. In his evidence, he has deposed that the claimant has suffered 18% disability to left lower limb and whole body disabilities is 6%. The tribunal has rightly assessed the whole body disabilities as 6%. Even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2016, the notional income has to be considered as 9,500. At the time of the accident, he was aged about just 26 years, 29 years. The multiplier applicable to the age group is 17. Accordingly, loss of future earning has been reassessed as follows. $1,16,280. Yes. Due to the accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 13 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering the wound certificate, and inclined to enhance the 40,000. Food and nourishment from 10,000 to 15,000. Conveyance charges 9,000 to 15,000. Attendance charges from 8,000 to 15,000. The compensation awarded by the and loss of later period for 5 months. The compensation awarded by the tribunal in the other hand are just and reasonable. 5 months ಅಂತಂದ್ರೆ ಡಬಲ್ ಈಗ ಏನಾಗುತ್ತೆ ಅದ್ರದ್ದು 5 months ಆಗುತ್ತೆ ಅಷ್ಟೇ. we have assessed the monthly income. Yes. ಕೊಟ್ಟಿದ್ದಾರ 25,000 they have given. Yes. Yes. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Insurance company is directed to deposit entire compensation amount with interest within 6 weeks from today. The tribunal is directed to release entire compensation amount with interest in claimant after due verification. Ready? Memo filed for dispensation of notice to R1. Memo is taken on record. Notice to R1 is dispensed. Yes. Case of death. Yes. Bachelor, 2018. Hmm. 24 years to 25 per month. Tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ 10. What is that 18? 12,000. 18. Future process ತಗೊಂಡಿಲ್ವಾ? 40%. 50% deduction. What about other head? Who are the claimants? Parents and brother Barala. Sorry. Sri Jagadish HT, Karnataka Council appearing for the claimant has contended that at the time of the accident, deceased was aged about 24 years and he was earning 25,000 rupees per month as a coolie. The tribunal has assessed the notional income of the deceased as 10,000 per month is on lower side. He further contended that view of judgment of apex court in case of Magma, in case of Pranay Sethi, 50% of the income of the deceased has to be added for future prospects. 15 in view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. Lastly, he has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Per contra, the Karnataka Council appearing for insurance company has contended that even though the claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the deceased as 10,000 per month. He further contended that since the claimant has failed to establish the income of the deceased, the tribunal has rightly not granted any compensation for future prospects. Lastly, he has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute. Umesh died in road traffic accident occurred on 26/10/2018 due to rash and negligent driving of driver of JCB bearing registration number KA06P368. Even though the claimant has claimed that deceased was earning 25,000 per month, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2018, the notional income has to be considered as 12,500. In view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. Since deceased is a bachelor, 50% of the income of the deceased has to be deducted for personal expenses. The multiplier applicable to the age group 24 is 18. Accordingly, loss of dependency has been reassessed as follows.
12,500 is 5,000 at a 40%, 17,500 minus 8,750 at a rate of 50%, 8,750 is 180, 18 lakhs 90,000.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, the claimant number 1 and 2 are entitled 40,000 each for Filial Consortium. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The insurance company is directed to deposit compensation amount with interest within 6 weeks from date of register of the copy of the stock.
I will take notice, my lord. I will take notice, my lord.
Yes. If respondent number 2 served unrepresented, E. Vijay Kumar is directed to take notice for respondent number 2. Karnataka counsel for the appellant is directed to serve one set of copies. Appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Service.
Much obliged.
Has happened that service. We should
94/21.
carry there. Ravi S. Sampati is directed to take notice for respondent number 2. Karnataka counsel for the appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed. You serve a copy to Ravi next week. Yes, appeal is barred by time. Application. Yes, week time is granted. Do the needful. Post first time notice ಕೊಟ್ಟಿದ್ರಾ?
Vijay Kumar sir. Sir, Vijay Kumar sir.
B. Pradeep is directed to take notice for respondent number 1. Karnataka counsel for the appellant has filed a memo seeking dispensation of service of notice to R2. Memo is taken on record. Service of notice to R2 is dispensed. You serve a copy to me.
For the appellant in this matter, my lords, the office objectives have been complied with, my lords. Process has been. Yes, my lords. Yes, my lords.
What about that process?
Also paid, my lords.
Karnataka counsel for the appellant has suggested that the appeal has been done. Office to verify and proceed further.
Great, my lords.
Who is that counsel appearing?
Lord, I will undertake to file wakalat, Lord.
ICIC were there, Mr.
Yes, Lord. Yes, Lord.
Keshav Prashant is directed to take notice for respondent number 1. Karnataka counsel for the appellant is directed to serve one set of copies. Karnataka counsel for the appellant has filed a memo seeking dispensation. Agidiyala. Yes. You serve a copy to Keshav. Yes, awaiting service of notice to 2 and 3. No, awaiting. Get the notice.
I appear for the appellant, my lord.
Yes, Mr. Keshav Prasad.
Lord, it seems that, my lord, by mistake I have filed the appeal before this bench. Should have been brought to the Harvard bench, my lord.
What do you want now?
My lord, I may be permitted to withdraw, my lord, this appeal. And office may be directed to, my lord, return the certified copy of the judgment and award passed.
Karnataka counsel for the appellant has submitted that seeking a leave of this court to withdraw this appeal with liberty to file same before that Harvard bench.
Please.
Yes, submission is taken on record. The above appeal is dismissed as withdrawn. Office is directed to return the certified copies of the judgment and award to the appellant, advocate for the appellant, after retaining the Xerox copy. Yes.
Along with the Milord, along with the check, I have deposited.
Amount also, Allah?
No. Statutory amount
Uh,
deposit ಮಾಡಿದ್ದೀವಿ.
As well as statutory amount deposited before this to that appellant. Return that statutory amount and also the certified copies.
अच्छा ओके.
Issue notice. Notice. Yes. Where is Dabali? Pass or we get him, we'll discuss. Maybe other quarter, otherwise we'll 2:30. Yes. Memo for dispensation of notice to R2. Learned counsel for the appellant has filed in a memo seeking dispensation of service and R2 is dispensed. There is a delay of 49 days in filing an appeal. IA-1 of 2020 is filed for condonation of delay. For the reasons in filing an appeal is condoned, IA-1 of 2020 is allowed. Yes, ready. Records is necessary. Yes, office is directed to secure original records from the film. Yes, ready, Mr. Dabali. You have not deposited that amount. Therefore, he is ready. ಅಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರು ರೆಡಿ ಇರೋದು, ಇಲ್ಲ ಅಂತ ಅಂದ್ರೆ ಡಿಪಾಸಿಟ್. ಹೌದು, ನೀವು KSRTC ಮಾಡ್ತಾ ಇಲ್ಲ, ಯಾಕೆ? BMTC KSRTC ಮಾಡ್ತಾರೆ, BMTC ದುಡ್ಡಿಲ್ವಾ? ಎಸ್. No, you are challenging that negligence also. Then records are necessary. Records ಬಂದಿ, then we'll have it 2:30. ಅಲ್ಲ, anyhow you are raised that you have to consider 2:30. Yes. Yes. But when do you want? Tomorrow. No, tomorrow. You have it tomorrow. You will not come. You want Dabali can argue that. Yes. Tuesday. Yes. Yes. Yes, Manjunath. Yes, week's time is granted to do the needful. Notice. IA-1 of 2021 is dismissed as not trust. Issue notice. Yes, IA-1 of Yes, IA-1 of 2021 is dismissed as not trust. Issue notice. Same. Who has filed that appeal? ಯಾರ ಹೆಸರು ಹೇಳ್ರಿ, ಅವ್ರಿಗೆ ಕೊಡಿ, ಫೈಲ್ ಕೊಡಿ. What about that respondent number 2, Mr. Memo padi. Learned counsel for the appellant has submits that the corporation is also filed an appeal represented by council N. ಯಾರ ಹೆಸರೇನ್ರಿ? ನಿರ್ಮಲಾ ಅಲ್ಲ, ನಿರ್ಮಲಾ ಅಂತ ಇದ್ದಾರೆ. SIM N. Yes, Nirmala. Office is the so and so is directed to take notice for respondent number 1. Learned counsel for the appellant is directed to serve one set of copies and counsel for respondent number 1. Yes. Appellant has filed a memo seeking dispensation of service of notice to R2. Memo is taken on record. Service of notice to R2 is dispensed at the risk of the appellant. Yes. Learned counsel for the appellant is submits that this appeal may be called along with the stones. Yes. IA 1 of 2021 is dismissed as not first issue notice. IA 1 of 2021 award furnished is non-challenging MEC. Yenidu CC copy of award furnished is of non-challenging MEC. Yeah, the different hakidare. Yes. Yes, where is Jagdish? Now he was there. Yes. None appear. Released this matter of 4 weeks. Notice. IA 1 of 2022 is dismissed as. Yara? Yes. Issue notice. Learned counsel for the appellant has filed a memo seeking dispensation of notice to R1, R2 and 3 is dispensed. Issue emergent notice to R1. One and 2 notice to 1 IA 1 of 2020 is dismissed as not trust. Filed in a memo dispensation of notice to 2 to 5. 2 to 5. Issue emergent notice to respondent number 1. IA 1 of 22 is dismissed as not trust. Yes, Malle. What is the date of the accident? 17, 11,000. ಏನ್ ಮಾಡ್ತಾ ಇದ್ರು ಅವರು? ಅದಕ್ಕೆ ತಗೊಂಡಿದ್ದಾರೆ. ಡ್ರೈವರ್ ಇಸ್ notice. Stay of judgment and award dated 24th December 2021 passed by small cause judge and the MEACT Bangalore in ECA number 109 of 2018. Only stay deposit enter. Yes, ready. Ready. 75. ಏನು ಇಂಜುರಿ ಏನಿಲ್ಲ, ಡಾಕ್ಟರ್ ನೇನು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ. ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದೀರಾ? ಆಯ್ತು, ಎಷ್ಟು ಕೊಡ್ಬೋದು? ಎಸ್ ಮಿಸ್ಟರ್. 75 ಇದೆ, 1 lakh ಮಾಡಿ. ಎಲ್ಲ ನೋಡಿ ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರು 75 ಕೊಟ್ಟಿದ್ದಾರೆ. ವಿಲ್ ಮೇಕ್ ಇಟ್ 1 lakh. ಎಸ್ ಮಿಸ್ಟರ್. 1 lakh with interest, mister. Then where is that record? Then we'll secure the record. Yes. Office is directed to secure original records post immediately after step records. Yes. ಅವರು ಮಹೇಶ್ ಅವರು will take notice. ಮಹೇಶ್
ಅವರು ಕೋಟಾ ನಂಬರ್ 31 ನಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ.
Yes, he has challenged on what ground, Mr. ಮತ್ತೆ ಅವರು ರೆಕಾರ್ಡ್ ಬರ್ಬೇಕು. ಮಹೇಶ್, ವಿತೌಟ್ ರೆಕಾರ್ಡ್ negligence arguments you will not take that matter. Yes, we direct Mahesh to take notice. We serve a copy to him. See, Mahesh is directed to Idrali, MFA problem. Directed to take notice for respondent number 2. What about that one, Mr. Vishnu? Issue emergent notice to respondent number 1. Agidagidara, you file memo. Karnataka Council for the appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed. Yes. You serve a copy to Mahesh.
MFP ಕ್ರಾಬ್ ಸ್ವಲ್ಪ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅನ್ಸುತ್ತೆ. MF 9117 of 180 ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. MF ಕ್ರಾಬ್ ಅಲ್ಲಿ 42.1.
ಎಷ್ಟಾಗಬೇಕದು?
2018 ಅನ್ಸುತ್ತೆ ಸರ್.
2018. ಅದು ಕೆಳಗಡೆ ಇದಾಕಿದ್ದಾರೆ.
180 ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ತಪ್ಪಾಗಿ.
Respond in the first matter and for the appellant the second matter, my lord.
Ready, Gunashekhar?
Yes, the case is filed. The insurance is third party insurance. The victim is the occupant of a private car. In view of the division there
liability dispute ಇದೆಯೇನು ರೀ?
ಹೌದು ಸರ್.
ಅವ್ರದ್ದು ಅಪೀಲ್ ಇದೆಯಾ?
ಹೌದು ಸರ್.
Is there any liability dispute? ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. Yes, you serve a copy to him, Mr. Gunashekhar.
It is served, my lord. The notice is ordered and it is issued, my lord.
ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತಲ್ರಿ? ಅಲ್ರಿ ಕೊಟ್ಟಿದಾರ ಇಲ್ಲ ಹೇಳ್ಬೇಕಲ್ಲ, ಕಾಪಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ ನಾನೇನ್ ಮಾಡಿ? ಕೊಟ್ಟಿದಾರ ಇಲ್ಲ ಹೇಳಿ, ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ I will ask him to give it, Mr. ನೀವು ಕೊಟ್ಟಿದ್ರೆ you request that, I will request my friend to get it copy ಅಂತ. ಅವರಿಂದ ಒಂದು ಕಾಪಿ, ಗುಣಶೇಖರ್ ಒಂದು ಕಾಪಿ ಕೊಡಿ, ಅವ್ರಿಗೇನೋ ಮಿಸ್ ಆಗಿದೆ.
ಕಳಿಸ್ತೀನಿ ಸ್ವಾಮಿ.
After 2 weeks. Yes, next week.
And after 2 weeks,
records are necessary. Is it?
Out, Swami, Bekko.
Office is directed to secure original records from the tribunal. Post immediately after receipt of the records.
Thank you.
Ready? Shri Shankar Reddy is directed to take notice for respondent number 2. Office is directed to show his name. Yes. 19 years. Doctor, we'll see where is the discussion. He has suffered stated the petitioner has sustained permanent physical disability of 35% to upper limb, 12% to the whole body. Yes. Doctor. Income ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? $2017. 11,000. What is your claim regarding the income? 11 days inflation. How much it is awarded? Medical expenses correct ಕೊಟ್ಟಿದ್ದಾರೆ. Transport charges, cost of amenities, attendance charges. Yes. 10% ತಗೊಂಡಿದ್ದಾರೆ, 12 ತಗೊಂಡಿದ್ದಾರೆ. ಅಲ್ಲ, ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಮತ್ತು ವೈ ಡಾಕ್ಟರ್ ಸೆಟ್ 12. Yes. ಟ್ರಿಬ್ಯುನಲ್ 10 ತಗೊಂಡಿದ್ದಾರಾ? Yes, 12. Shri Shantraj K, Karnataka Council appearing for the claimant has contended that at the time of the accident, the claimant was earning 15,000 per month as a coolie. The tribunal has considered the monthly income of the claimant as 8,000 per month is on lawyer side. He further contended that due to the accident, the claimant has suffered a crush injury. He has examined the doctor. Doctor has assessed the disability is permanent physical disability of 35% to the upper limb and 12% to the whole body. The tribunal has assessed whole body disability is 10% is on lawyer side. He further contended that due to the accident, the claimant has suffered grievous injury. He was inpatient for a period of 11 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of amenities, no loss of income during the later period. Why? Loss of amenity. Huh? Oh, yes. The compensation awarded to the tribunal, pain and suffering, loss of amenities, other incidental expenses is on lawyer side. Hence, he sought for enhancement of compensation. For contra, Sri Reddy, learned counsel appearing for the insurance company, has contended that even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 8,000 per month. He further contended that the injuries suffered by the claimants are minor in nature. Even the doctor has assessed that whole body disabilities is, our doctor has assessed permanent physical disability of upper limb is 35%. Considering that evidence of doctor, considering that wound certificate, the whole body disabilities assessed by the tribunal is just and reasonable. He further contended that considering that injury suffered by the claimant, considering the evidence of doctor and wound certificate, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Third, the learned counsel for the parties, whereas judgment and award. It is not in dispute. The claimant has suffered an injury due to in road traffic accident occurred on 30/7/2017 due to rash and negligent driving of rider of motorcycle bearing registration number AA64L3115. Due to that accident, the claimant has suffered the following injury. He has examined the Dr. Prasad as PW2. He needed evidence. He has categorically deposed that the claimant has suffered permanent physical disability of 35% to the right lower limb, upper limb, and 12% to whole body. Considering that evidence of doctor, considering that wound certificate exhibit P3, I am of the opinion that the whole body disabilities has to be assessed 12%. Even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2017, the notional income has to be considered as 11,000. At the time of the accident, he was aged about 19 years. The multiplier applicable to the age group is 18. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, the claimant has suffered the following injury. He was inpatient for a period of 11 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that wound certificate, I am inclined to enhance the compensation for loss of immunities 25,000 to 40,000. Attendance charges from 5,000 to 12,000. Loss of income during the later period is for 3 months. Accordingly, corrected. Yes. Food and nourishment 10 ಕೊಟ್ಟಿದ್ದಾರೆ, transportation charges ಕೊಟ್ಟಿದ್ದಾರೆ, amenities 40, attendance charges ಎಷ್ಟಿದೆ? 5 to 12,000. Yes. Loss of income during the later period for 3 months. Accordingly, the appeal is allowed in part. Judgment and award passed to the tribunal is modified as follows. ಖಂಡನ ಆಗಿದೆ. Yes, Vijay Kumar.
Number 45, B. Vijay Kumar for appellant.
Pass over. Yes.
Number 46, judge of person for appellant, matter,
Yes. For the appellant in this case, Malad, liability is questioned. TC is required.
TC are required. We'll condone that delay of 166 days.
Please, madam.
Yes, there is a delay of 166 days in filing an appeal. IA 1 of 2019 is filed for condonation of delay for the reasons stated in the accompanying affidavit. Delay of 166 days in filing an appeal is condoned. IA 1 of 2019 is allowed. Office is directed to secure original records from the tribunal. Post immediately after receipt of the copy.
Please.
Who is that? Harish, who claimant? Claimant. No, he is an injured. He is an injured. During the pendency of the appeal or during the pendency of the appeal? Oh. No, he was a minor. Harish. Indramma. Then your appeal? Alright, ಅವರಲ್ಲಿ ಇದ್ಯಾರ್ದು appeal ಇದು? Insurance company appeal ಅಲ್ಲಿ represented by Indramma. ನಿಮ್ದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದೀರಾ? ಅದು ಮೆಮೊ ಹಾಕಿವನ್. Otherwise ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಹಂಗೆ ಬರುತ್ತೆ. Now he is dead now. It has to be treated as a dead. Bro, you also file a memo, mister.
Please, madam, please.
Yes.
Well, death certificate, one copy of death certificate may be furnished.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಒಂದು ಮೆಮೊ ಕೊಡಿ. Manjunath. Yes. Then appear. Release this matter of 2 weeks. Date of judgment is strongly stated. Ready, mister? Yes. 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 Doctor examine ಮಾಡಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ? For 14. Shown so 14 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? ಅಲ್ಲ ಇರ್ಲಿ ಇಲ್ಲಿ ವೇರ್ ಇಸ್ ದಟ್ doctor said that it is a
so assess the whole body disability is also open sleep and disability
right from the so he assessed whole body disability is 59%. Yes. What is that disability taken by the tribunal? 50%. Tribunal 50. Is a
driver mala. He produced the document from the exhibit B8. He is dealing the transaction mentioned. It's not suggesting anything regarding the driver mala.
Now that what is that injury? Right upper and lower limb. Studying speech and memory impairment, neurological assessment was done. Below average intelligence sounds. Yes.
This is also not awarded by the tribunal. There's a 59% of the whole body physical problem.
Yes. Now, what is the income you have claimed?
20,000.
Tribunal ಎಷ್ಟಾಗಿದ್ದಾರೆ? ಆಯ್ತು What is the date of the accident? 2016. Yes.
Age of 25 years.
Yes. Yes. Yes.
Nature of injury is very big and marriage perspective is not awarded by the tribunal.
ಆಯ್ತು ಅದ್ರ ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ ಕವರ್ ಆಗುತ್ತೆ.
And future prospect ತಗೋಬೇಕು more than 59% future prospect period.
Yes. Yes. Loss of future earnings due to the permanent disability. Yes.
And future.
Yes. That's all. Yes, Mr. That's all. Yes, Mr. Reddy. Yes.
The document for exhibit B8. Real and not real. Heavy vehicle real.
Exhibit
B8. Even the evidence for it. It's not providing this answer.
No, is it your case that I'm doing driving and this thing? ಅಲ್ಲ ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿದ್ಯಾ? ನಾನು ಏನು ಡ್ರೈವಿಂಗ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೆ ಆತನ ಎಲ್ಲಿ ನನಗೆ ಏನಾದ್ರೂ ಒಂದು ಲಾರಿ ಇತ್ತು ನಾನೇ ಓಡಿಸ್ತೀನಿ ಸಂಬಳ ಬಂತು ಎಲ್ಲಿ ನಿಲ್ಲಿಸಿ ವೇರ್ ಇಸ್ ದಟ್? ಅಲ್ಲ ಡ್ರೈವರ್ ಅಂದ್ರೆ ಈಸ್ ವರ್ಕಿಂಗ್ ಇನ್ ಎನಿ ಅದರ್ ಕಂಪನಿ ಆರ್ ರೆಗ್ಯುಲರ್ ಡ್ರೈವ್ ಏನ್ ಡ್ರೈವರ್ ಬಸ್ಸೋ ಲಾರಿನೋ ಏನ್ ಹೇಳಿಲ್ಲ. He has taken only a driving license. Yes. I asked evidence ಬಂದ್ರೆ ಸಾಕು. DL ಇದ್ದು if you say I'm regularly ಯಾರ್ದೋ ಒಬ್ರು he's a driver, there is no doubt because he need some ಯಾಕಂದ್ರೆ driving license ಇರೋದ್ರಿಂದ ಎಲ್ಲರೂ at least he could have said I will consider which is that DL. ಆಯ್ತು will consider since he has in a DL. Yes. ಮತ್ತೆ ಅಷ್ಟೇನಾ? That's all covered under that pain and suffering, loss of immunity. 3 lakhs he has covered. No, is it your case that you have surrendered the DL? You are not working. Allah, you have to surrender the DL. That is the main thing. Okay, we'll consider.
Laid up period at least 1 month, 3 months, at least 6 months. Laid up period. Food and nourishment separate again award.
Criminal monthly ಎಷ್ಟಾಂಡಿದ್ದಾರೆ?
Medical hospital. 33 days patient ಅಲ್ಲ.
No, that 42,000 loss of earning ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ.
Loss of earning 3 months ಕೊಟ್ಟಿದ್ದಾರೆ. Later on injuries at 6 months.
6 months ಕೊಟ್ಟಿರೋದು ಅದು. ಮತ್ತೆ ಆ 6 months ಐತೆ. ಈಗ ಇನ್ಕಮ್ ಜಾಸ್ತಿ ಆದಾಗ ಆ 6 months ಆಗುತ್ತೆ, ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅಲ್ಲಿಗೆ ಆಟೋಮೆಟಿಕ್ ಆಗಿ. 33. Yes. Dale. Shri Raju S. Learned Council appearing for the claimant has contended that at the time of the accident, he was earning 20,000 per month as a driver. To prove that, he has produced the DL as Exhibit P8. The tribunal has considered the notional income of the claimant as 7,000 is on lower side. He further contended that due to that accident, he has suffered grievous injury. He has examined the doctor. Doctor has assessed that whole body disabilities is 59%. Due to that injury, he was unable to do his day-to-day work. The tribunal has not considered future prospects, and the whole body disabilities assessed by the tribunal is also on lower side. In support of his contention, he has relied on judgment of apex court in case of Poppu D.O. Yadav and others. He further contended that due to that accident, he has suffered grievous injury. He was inpatient for a period of 33 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of amenities and other incidental expenses is on lower side. And the tribunal has failed to grant any compensation for loss of marriage prospects. Hence, he sought for enhancement of compensation. For contra, Shri Reddy Learned Council appearing for the insurance company has contended that even though the claimant has claimed that he was earning 20,000 per month as a driver, except producing the DL, he has not examined the employer, or he has not produced any bank statement to show that he was earning 20,000 per month. He further contended that the tribunal, after considering the evidence of the doctor and injury suffered by the claimant, has rightly assessed that whole body disabilities is 50%. Lastly, he has contended that considering that injury suffered by the claimant, considering that evidence of doctor and wound certificate, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties, peruse judgment and award and original records. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 29/5/2016 due to rash and negligent driving of driver of the rider of motorcycle bearing registration number KA04EZ8049. Due to that accident, the claimant has suffered the following injury. He has examined the doctor. What is the name of the doctor, Mr.? Who is Dr. PW? Aurena, Nadi.
Dr. Veeresha U. Mathad.
Yes. He has examined the doctor Viresh U. Mathad as PW2. In his evidence, he has deposed that the claimant has deposed that he was suffered neurological disability which is not. He has deposed that the claimant has a permanent neurological disability which is not going to improve in future, and he has assessed whole body disabilities is 59%. Considering that evidence of doctor and considering the wound certificates exhibit P7 and exhibit P15 neurophysical assessment report, and discharge summary exhibit P28 and P29, I am of the opinion that the whole body disabilities has to be assessed 59%. Even though since he was a driver, he has produced driving license as exhibit P8. He has produced driving license as P8, and he has suffered a neurological disability. Considering the same, I am in view of the judgment of the apex court in case of Pappu, so and so, the claimant is entitled for future prospects. In view of judgment of apex court in case of Pranay Sethi, what is his age? The 40% of the income of the deceased has to be added for future prospects. Even though the claimant has claimed that he was earning 20,000 as a driver and he has produced the DL, he has not produced any other documents, much less bank records, to show that he is getting 20,000 per month, and he has not employed his employer to prove that he is getting 20,000. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2016, the notional income has to be considered as 9,500. The multiplier applicable to the age group which is 18. Accordingly, loss of future earning has been reassessed as follows: 59% plus 40%.
3,800 at the 40%, 13,300, 13,300, 18%, 16 lakhs, 94,052.
Yes. Due to that accident, the claimant has suffered the above said injury. He was inpatient for a period of 33 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unattendance. Considering that evidence of doctor, considering the wound certificate, the compensation awarded by the tribunal, pain and suffering, loss of immunities, and other incidental expenses is just and reasonable. The loss of income during the later period has to be granted for 6 months. Accordingly, the appeal is allowed in part. Judgment and award. Pain and suffering only 2 lakhs. Loss of immunities 1 lakh. See, therefore, what is granted by the tribunal, that has been double. 7,50,000 our ಮಾಡಿದ್ದು ನಾವು 16 lakhs ಬಂದಿದೆ. Therefore, I have calculated everything. Then I said that which is therefore I have 59% plus 40% future prospects. That has been considered. Yes. If future prospect is not there, otherwise I could have enhanced that compensation. Yes. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Yes. You want time? Is it a case of death? Are you disputing? Whether you are disputing any this thing, liability, only quantum. Then what is there? You will see. Wakalat will permit you to file an wakalat. We'll see that if there is no dispute regarding that liability, then you can dispose of. Yes, mister. Or you want time? Yes. At the request of counsel for respondent number 3, release this matter after 2 weeks. Yes. Any date? 15th. Yes. What is this, Mr. Dabali? Yes. Heard. Issue notice. Stay of judgment and award dated 11th February 2020-21. Passed by MECT Bangalore in MEC 2038 of 2013. Subject to condition, appellant has to deposit 50% of the award amount with interest within 4 weeks from today before the tribunal.
I appeal for the appellate, my lord. My lord, this is a CH-16 appeal, my lord. The MAT has erred in granting compensation, though she is a student.
Yes.
It has considered the future prospects also, and depending upon the Mallikarjun's case, it has wholly granted award for ₹3 lakhs. Apart from granting 3 lakhs, it has also passed an award under the head, my lord. Amenities and marriage prospects, 3 lakhs it has been awarded, and also loss of income, future income, 3,78,000. This is wrong, my lord. It is against the Mallikarjun judgment.
Notice stay of judgment and award dated 31st July 2021, passed by MECT Tumkur in MEC 616 of 2019, subject to condition. Appellant has to deposit 50% of the award amount with interest before the tribunal within 4 weeks from today. Water has not been incoming. Damage, vehicle damage. Yes. Then why is it they show that injury case? I anta ತೋರಿಸಿದ್ದಾರೆ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ. Is it correct, Mr.? The petitioner himself was related towards damages. Yes. Issue notice. Stay of judgment and award dated. What is the date? 12/8/2021. Passed by Senior Civil Judge JMFC Hassan in MEC 1479 of 2019, subject to deposit of 50% of the award amount with interest within 4 weeks from today before the tribunal. Three, before the trial court, Timaya is dead. Appeals are. Yes, Mr. Ravi, what is it? Have you stated in that? Yes. Who has that? Learned counsel for the appellant has submitted that the claimant number 3, Timama, died during the pendency. During the pendency of the claim petition. The appellants or LRs of deceased Timama, they are already on records. Therefore, he submits that office objection may be overruled. Submission of learned counsel for the appellant is taken on record. The office objection is overruled. Notice.
I appeal for the appellant, my lord. The case at appeal, my lord. In this case, the MAC erred in granting the compensation under several heads, my lord. In that, the evidence clearly speaks that he has not undergone surgery, but the MAC considers the disability at 10%. Without there being any documents, the MAC has granted heavy award on exorbitant.
Issue notice. Stay of judgment and award dated 28th October 2021, passed by MECT Kollegala in MEC 359 of 2018, subject to condition. Appellant has to deposit 50% of the award amount with interest within 4 weeks from today before the tribunal. Yes, notice. 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 Yes, Limraj. Number 61. Also. Number 62. Is Pradeep for appellant. Is open up. Yes. Ready. Yes, at the request of counsel for the appellant. ಅದು ಎರಡನೇದ್ರಲ್ಲಿ ನೀವು ನೋಟಿಸ್ ತಾಣ್ತೀರಾ ಕೊಡಿ. What about that other? No, if you connect this matter, this is the problem. Process is not completed. Matter is for the hearing. ಕೊಡಿ. B. Pradeep is directed to take notice for respondent number 2. Who is Satish? No, they are not coming. Whether they want to dispense or who is that respondent number 2, Mr. Abdul Wahid. In case ಅಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಕೊಡಿ ಅದು ನೋಡಿ. ಅಬ್ದುಲ್ ವಹಾಬ್ ನೀವೇ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದ್ರ ಅಂದ್ರೆ ಅವ್ರದಲ್ಲೂ ಡಿಸ್ಪೆನ್ಸ್ ಮೋಸ್ಟ್ಲಿ ಬಟ್ ವೇರ್ ಇಸ್ ಸತೀಶ್ HK? Yes, B. Pradeep is directed to take notice for respondent number 2. Yes, at the request of counsel for Pradeep B. Relist this matter 2 weeks. Yes, for appellant is Pradeep who are ಕೊಡಿ ಅದು. We'll take notice for R2. Yes. E. Pradeep is directed to take notice for respondent number 2. What about that other respondent, Mr. R1? R1 Shivamma. Our Nodi Mali Patil. Mali Patil is appearing for whom? Huh? Huh. How's Raghu appearing for whom? Ibru climates. Nimda Mali Patil, you are appearing for the parents. New respondent is really. You are in a respondent before the tribunal. Wait. Now you have filed an appeal and claimant is also filed an appeal. Then in your case, in Raghu case, in hearing notice about our case, PS Mali Patil agide R1 yaradu Shivamma. Shivamma R5 ಯಾರಿದ್ದಾರೆ first case ಅಲ್ಲಿ. PS Mali Patil R2 and R4. Pradeep R6. Dispensed notice to R5. Who is R5? Owner of the vehicle. The insurance policy, is there any dispute? Huh? Insurance company ಮೇಲೆ liability ಹಾಕಿದ್ದಾರೆ. ಯಾಕೆ? ಯಾರಿಗೆ? Liability insurance company ಮೇಲೆ ಇದ್ರೆ ಓನರ್ ಯಾಕೆ? No, you are appearing for whom, Mr. Respondent number 1 are jointly severally liable to pay 1 and 2 ಅಂತಂದ್ರೆ insurance company. Yes, liability, there is no liability dispute. ನೀವು ರಘುಗೆ ಅಲ್ರಿ, ನೀವ್ ಯಾರಿಗ್ರಿ? ವಿಚ್ ಕೇಸ್? ಮತ್ ನೀವ್ ಹೇಳ್ಬೇಕಾ ಬೇಡ? ವಾಟ್ ಯು ಸೇ ಅಬೌಟ್ ದಟ್ ಪ್ರೋಸೆಸ್, ಮಿಸ್ಟರ್? ಮತ್ ಅದನ್ನ ಹೇಳ ಇಷ್ಟದಂಕ ಐ ಆಮ್ ಸರ್ಚಿಂಗ್ ಹಿಯರ್ ಅಂಡ್ ದೇರ್. ಯು ಫೈಲ್ ಇನ್ ಎ ಮೆಮೊ. ಎಸ್, so and so learned counsel appearing for appellant has filed in a memo seeking dispensation of service of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed. ನೀವು ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ? ಅಲ್ರಿ, ನೀವೇನಕ್ಕೆ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ? Only quantum. Then ready? Why? What is that dispute in that quantum, Mr. Raghu? What is he? Sahaba is sleeping open place cottage. No, ಅವ್ರು ಏನಾದ್ರೆ ಲಯಬಿಲಿಟಿ ಮೇಲೆ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರೆ ಹೆಂಗ್ರಿ ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿಯವರು? ಪ್ರದೀಪ್ ಅವ್ರು ಕೊಡ್ರಿ, ಏನ್ ಗ್ರೌಂಡ್ ತಗೊಂಡಿದ್ರಿ? ಮತ್ತೆ ಲಯಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ. ನೋಡೋದೇ ಇಲ್ಲ ಒಬ್ರು ಫೈಲ್. ನಿಮ್ದ್ರಲ್ಲಿ ಯಾರ್ಯಾರಿಗೆ ಪ್ರೋಸೆಸ್ ಆಗ್ಬೇಕು? Then you have to take notice for Shivamma. Yes. ಇದರಲ್ಲಿ 63.2 ಅಲ್ಲಿ weeks time is granted to pay the process to issue notice to R5. Return with process ಯಾರಾದ್ರು insufficient address, Mr. You have to produce proper address. R5 ಯಾರು? ಅದಕ್ಕೆ ಅವ್ರು ಮೆಮೊ ಹಾಕ್ಬೇಕಲ್ಲ ಅಲ್ವಾ? Yes, weeks time is granted to pay process, issue correct address, furnish correct address to issue notice to respondent number 5. ನಿಮ್ದೇನು why that dispute parents ಗೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಇಬ್ರಿಗೂ ಸೇರಿ 10 ಅಥವಾ ಒಬ್ರೊಬ್ರಿಗೆ 10? 5. Who are that other claimants? Wife and children. 1, 2, 3, 4. 20, 40, 60. ನೀವೆಲ್ಲ 20% ಅವರಿಗೆ 10% 20 ಸರಿ ಆಗುತ್ತೆ. ಲೆಟ್ ಅಸ್ ಸಿ ಫಸ್ಟ್ ಅವ್ರ ಕೇಸ್ ಇದಾಗಬೇಕು. See that. To take steps, Mr. For this correct. Radha Swami. Pass out.
Respondents.
Yes, pass out, madam.
Much obliged.
ನೋವಿತವೆ ಮತ್ ನೀವು ಬೆಳಿಗ್ಗೆ ಹೇಳ್ಬೇಕಾ ಬೇಡ? ಇದು ಅರ್ಜೆಂಟ್ ಆಯ್ತಲ್ಲ, ಏನಾಯ್ತು? ಎಸ್ ಕೊಡಿ ನಂಬರ್ ಅದೇ. ಎಸ್ I'm calling a performance password. Income? ಎಷ್ಟು ಅನ್ಬೇಕು? What is the date of the accident? ಯಾವಾಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಬಂದಿದೆ? 10 ಅಲ್ಲಿ ಬಂದಿದೆ ಅಂದ್ರೆ 8,000. ಅವ್ರು ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಕ್ರಿಮಿನಲ್ ಅವರು? ಯಾರ ನಂಬರ್? Where is that discussion, Para? ಅವ್ರೇನು ಮೋಟರ್ ವೆಹಿಕಲ್ಸ್ ಇದ್ರ ಪ್ರಕಾರ ಮಾಡ್ಬಿಟ್ಟಾರೇನ? ಇಸ್ ಇಟ್ ಮಿಸ್ಟರ್? ನೀವ್ ಎಷ್ಟು ಕೇಳಿದ್ರಿ ಮಂತ್ಲಿ? 10,000 ಆಗಿತ್ತಾ? ಇದ್ರಲ್ಲಿ 8,000 ಇದೆಯಲ್ಲ ಮಿನಿಮಮ್. ಮತ್ತೆ ಫ್ಯಾಕ್ಟರ್ ಎಷ್ಟು ಬರುತ್ತೆ? ವಾಟ್ ಇಸ್ ದ ಡಿಸಬಿಲಿಟಿ? ಎಲ್ಲಿದೆ? The whole body against the disability 30% certified by the doctor. Consider 10% ತಗೊಂಡಿದಾರಲ್ಲ. 10% ಗೆ ಫ್ಯಾಕ್ಟರ್ಸ್ ಎಷ್ಟು ಬರ್ತದೆ? ಮತ್ತೆ ಅಲ್ಲ, ಇನ್ಕಮ್ ಅಲ್ಲಿ 50% ಮಾಡ್ಬೇಕಾ 60%? 60% has to be considered. Yes. Where is Hegde? Where is Hegde, Mister? Hegde na? Hegde Mulkan?
Within 31 court, my lord.
31. Pass out. ಬರ್ಲಿ ಅವ್ರು ಕರ್ಕೊ ಬನ್ನಿ ಸರ್, ಅಷ್ಟೇ ಅಲ್ಲ ಇದು. ಮಹೇಶ್ವರ್ ಗಾಂಧಿ
number 5, Mandula and Telecast.
Yes, Manjula. Pass out.
45. The Vijay Kumar for appellant. It is Vijay Prasad.
Yes. Yes, where is your opponent, Mr. What is this matter? On what ground they are challenging? In the quantum. Where is Vijay Kumar? What is the date of the accident? Oh. Yes, what was he? ಎಷ್ಟು ಇನ್ಕಮ್ ದುಡ್ಡಿನಲ್ಲಿ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 11,000. ಮತ್ತೆ ಈ ಡಿಸಬಿಲಿಟಿ ಟ್ರಿಬ್ಯುನಲ್ ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರೆ. Disability the petitioner 32 that whole body tandidare 30 tandidare. Where is the doctor? Assess the disability factor of the petitioner's whole body. 33 ಹೇಳಿದ್ದಾರೆ but 30 ತಗೊಂಡಿದ್ದಾರೆ. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? ಮತ್ತಿನ್ನೇನಿದೆ? Pain and suffer. Medical expenses 127. Transportation and nourishment. Medical expenses as it is ಕೊಟ್ಟಿದ್ದಾರೆ. Future and towards the future medical expenses 1 lakh. Where is that discussion for 1 lakh? Amenity 75,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Yes. Only that income has to be reduced. That's all. Up to 3 days. Yes. ಎಲ್ಲಿ ಇಲ್ಲಲ್ಲ ವಿಜಯ್ ಕುಮಾರ್, ವೇರ್ ಇಸ್ ಹಿ? Amputation. Yes. Doctor evidence. ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಯಾವ ಅಲ್ಲ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ? Where is he? Call him. He told you to come. Evidence by a particular sound. ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? Pastor, if he is there, you get him to discuss. There are no other matter. So what is that? It is only a case of death. The connected matter is yeah. No, but today all matters are over. ಯಾಕ ಇದನ್ನ ಅದನ್ನ ಜೊತೆ ಮಾಡಕ್ಕೆ ಅದು yes at the request of counsel for respondent appellant release this matter next week. Yes madam.
ಅವ್ರು ಅಪೀಲ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಸಮ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಗೆ.
And what is their ground? ಯಾರು ಇದ್ರಲ್ಲ ಮಾಧವ
ಹೇಳಿದೆ ಸಮ್ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದೆ ಈಗ ಅವ್ರಿಗೆ ಅಲ್ಲೆಲ್ಲ ಹೊರಗಡೆ ಇದೀನಿ ಬರ್ತೀನಿ ಅಂತ ಅಂದ್ರು. ನಾನು ಹೇಳಿದೆ ರೀಚ್ ಆಗಿ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದೆ ಫೋನ್ ಮಾಡಿ. What is that income assessed by the tribunal? ಸ್ಟೂಡೆಂಟ್ಸ್ 16 ವರ್ಷ ಸ್ಟೂಡೆಂಟ್ 4000 rupees ಏನೋ ತಗೊಂಡಿದ್ದಾರೆ ಇನ್ಕಮ್.
ಎಷ್ಟಿದೆ ಇಂಜುರಿ? ಡಿಸಬಿಲಿಟಿ ಏನಾರು ಇದೆಯಾ?
ಡಿಸಬಿಲಿಟಿ 10% ಹೋಲ್ ಬಾಡಿ ಹೇಳಿದ್ದಾರೆ, ಅದನ್ನೇ ತಗೊಂಡಿದೆ ಸ್ವಾಮಿ ಇದು ಟ್ರಿಬ್ಯುನಲ್. ಡಾಕ್ಟರ್ ಶಿ ವಾಸ್ ಇನ್ಪೇಷಂಟ್ ಫಾರ್ 40 days ಅಂತ ಹೇಳಿ.
What is his age?
16 years ಸ್ವಾಮಿ ಅವಾಗ ಆಕ್ಸಿಡೆಂಟ್ ಅಲ್ಲಿ.
Master Mallikarjun. Mahesh, which is your matter? Mahesh,
ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು ಮ್ಯೂಟ್ ಆಗಿದೆ. ಮಾದೇಸ್ವಾಮಿ ಬರ್ಲಿ ಸ್ವಾಮಿ.
ಮೈಕ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ಸರ್ ಮಹೇಶ್ ಸರ್.
ಅದೇ ಮ್ಯೂಟ್ ಮಾಡಿದಾರೆ ಅವರು.
Serial number 65, my lord.
65 ಅವರು ಶ್ರೀನಿವಾಸ್ ಅವರು ಬೆಳಗ್ಗೆನೆ 2 weeks ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್. ಫಸ್ಟ್ ಅವರ್ ಅಲ್ಲಿ.
Somebody has taken time, Mr. Mahesh.
And one suggestion, my lord.
Yes.
In the display, my lord, they can as well as show that what are the matters urgent, my lord, so that it will be easier for
No,
us to.
that options is not there. Earlier it was there. Pass over ಮತ್ತೆ idittu. Now they have not made that options.
I have requested the computer registrar to reintroduce, my lord.
I think they have to change the software itself.
No,
Let us see. Let us see. We'll take that suggestion.
My lord, that's all.
No, that suggestion. We'll take that suggestion. Yes, we'll also put into that committee before the committee whether it can be.
Yes. Serial number 42 admission was there, my lord.
42 ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಆಗಿದೆ ಸರ್. ನಿಮ್ಗೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸಾಹೇಬ್ರು. Respondent number 2.
Yes, they have been asked to serve a copy to you, Mr. Mahesh.
May I know the number, my lord?
MFA CRAB
48 of 2019, sir.
48
MFA
of
cross
2000.
subsection 48 of 2019.
Thank you, thank you.
Yes, pass over. Ask him to come at 2:30, madam.
Yes, madam.
Pass over. Sitaram. Yes, 2:30, Mr. Gujjar. Yes, 5 also, she is not there. Ask her to come 2:30. There is no other matter we will discuss. Two thirty ಬನ್ನಿ. ಇಲ್ಲ ಅದೇ 3 ಮ್ಯಾಟರ್ ಇರೋದು. ಸರಿ.
ನಿಮ್ಮವ್ರು ಯಾರು ತಗೊಂಡೋಗಿರ್ತಾರೆ? ಹೌದಾ, ನಾನು ನೋಡಿಲ್ಲ, ಅವರೇ ತಗೊಂಡೋಗಿರ್ತಾರೆ. ಇನ್ಯಾರು ತಗೊಂಡು?
Court officer. Court officer.
ಸರ್ ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 17 ಹಾಗೆ 70 ಹಾಗೆ ಇದೆಯಾ?
ಹಾಗೆ ಇದೆ.
ಅದರೊಳಗೆ ಇದೇ ಕೊಟ್ಟಿಲ್ಲ, ಕಾಪಿನೇ ಕೊಟ್ಟಿಲ್ಲ ಸರ್, ಡೈರೆಕ್ಟ್ ನೋಟಿಸ್ ಆಗಿತ್ತು ಸ್ಫೂರ್ತಿ. ಒಂದು 2 weeks ಟೈಮ್ ಹಾಕ್ಬಿಡಿ ಸರ್.
ಸರಿ ಹೇಳ್ತೀನಿ ಸರ್. ಸಾಹೇಬ್ರೆ ನೀವು ಇರಿ ಸರ್, ಏನಿದ್ರು ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟ್ರ್ ಅಷ್ಟೇ.
ಅಲ್ಲ ಬೆಂಚ್ ಇದೆಯಾ?
ಇಲ್ಲ ಬೆಂಚ್ ಇಲ್ಲ, ಡೈರೆಕ್ಟ್ ಈಗ. Last over matter, serial number 5. One should have
With kind permission, my lord.
I was told that.
Yes, Mr. Hegde.
With kind permission. Serial number 70, my lord. He had not served copy so far, my lord. I request 2 weeks time, my lord.
Hegde, in that case, see, only thing is that it is an Workmen Compensation Act.
My lord, my humble submission is, my lord, it's a private company, my lord, so they will take, my lord.
You will give a time. Only thing
Next
is
time
that
I will do it, my lord.
Fixed salary, that income has to be taken 8,000 as per that notification.
Correct, my lord. Correct.
Then
So
interest
2
has to be
weeks
given for a
time.
12%, 9% has been given. Only the 2 grounds.
Yes, my lord. So after 2 weeks, my lord.
Let us see. See, the problem is today I don't have any case. Therefore, I am holding up all advocates.
Because I was held up, my lord, morning
I have
nearly 1 hour.
raised at 12:30.
My lord, Lok Adalat and this one, my lord, quota number 31, I was held up. Sorry, my lord, morning I could not make him.
Respondent number 1. Release this matter of 2 weeks. Serial number 7.
Okay. Sorry for inconvenience, my lord. Sorry for inconvenience.
Yes. Serial number 5. Ready, madam? Yes. Yes. No, you said there is no dispute regarding that liability.
I have raised an issue on the liability aspect also because though the accident has occurred on 14/2016.
Yes.
He got admitted in the hospital only after 6 days.
Yes.
He says that the accident occurred on 14/2016. He got admitted in the hospital on 18/2016, and he had fractures of both the bones of right arm. So ಅದಕ್ಕೆ ಅವರು ಮಣಿಪಾಲ್ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದಕ್ಕೆ ಏನು ರೆಕಾರ್ಡ್ಸ್ ಹಾಕಿಲ್ಲ. Therefore, I have raised that issue in my appeal memo, but court ಮುಂದೆ
Yes, admitted that accident. See, what is the date of the accident? 14/2/2016.
10:30 a.m.
10:30. See, when that admitted to the hospital,
18/2/2016.
18/2/2016.
That too with 2 fractures of both the bones of right arm.
Delay. What is the date of the complaint?
Complaint on 19th, the next day. After on the next day of the admission into the hospital. ಏನಾಗಿದೆ? Even owner also says that ಅವರೇನೋ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ರಂತ ಅವರಿಗೆ 20,000 ಅದಕ್ಕೆ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಕ್ಕೆ ಅದಾದ್ಮೇಲೆ ಕೇಸ್ ಮಾಡಿದ್ದಾರೆ.
That is his case. Let him. You make your submission.
My submissions are that will not ship. It's actually a false case in collusion with the owner of the vehicle. They have foisted a false case against the insurance company only to see that the petitioner is benefited under this. Because if at all he had sustained any injuries in the alleged accident,
yes,
he would not. His circumstances will never permit him to stay back.
Yes.
The nature of injuries and all. And when he claims that he was admitted in Manipal hospital and he took a treatment there,
No,
nothing
for that, you have examined anybody?
ಇಲ್ಲ ನಾವೇ examine our documents ನಾವೇನು examine ಯಾಕೆ
Examine.
ಮಾಡ್ತೀವಿ?
No, you are
Because
not.
it's a case of
No, your case is that he has admitted to the hospital after 4 days. Complaint is after 5 days. On that basis only you are. There is no. Have you examined that insured?
it is their admitted case.
No, even then.
Insured, the insured come over. That is the rider come.
No, see, even there is a complaint. FIR is there, document is there. Just because of delay, Supreme Court said you cannot say that. You have to see other circumstances whether accident is actually occurred or not. Therefore, suppose if you are examining any persons to prove that there is no accident has occurred on that day, then we can see that evidence. There is no. But owner has given evidence against you. Other than that, any other evidence to prove your, allegation?
I could not see the entire file.
Records ಬಂದಿದೆಯಾ?
Records are necessary.
We'll check it records.
Even because I have raised an issue on the liability aspect of it.
Yes.
To respond about it, that is the issue is this.
What has happened to that? So what has happened in that trial court? He has appeared, Allah.
At the same address, he has been served.
ಏನಾಗಿದೆ ನೋಡಿ notice ಅಲ್ಲಿ.
Served that address not complete ಅಂತ ಇಲ್ಲ ಬಂದಿದೆ. ಅದೇ address ಮೇಲೆ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಿ ಬಂದಿದ್ದಾರೆ.
What is that address ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಸೂರಜ್ ಕುಮಾರ್ ಸೋನಾರ್, son of Uttam Bahutu.
How can it go, madam? HSR layout number 157 ಕ್ರಾಸ್ ಕೇಸ್ ಏನು ಇಲ್ಲ ಅಲ್ಲ.
ಇಲ್ಲ ಇಷ್ಟೇ ಇದೆ ಸರ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅದೇ ಅಡ್ರೆಸ್ ಇದೆ.
Trial court ಅಲ್ಲಿ somebody has informed he has come ಅಂತ ಕಾಣಿಸುತ್ತೆ. Trial court ಅಲ್ಲಿ he has appeared. ಇಲ್ಲಿ ಏನಂತ ಬಂದಿದೆ? Insufficient address. You have no any other documents?
Insurance policy is ಅದೇ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
Same
ಅದೇ
address.
ಅಡ್ರೆಸ್ ಕೊಡಿ.
ಏನಂತಿದೆ? Oh. Owner, yes, you take down that number. And I think it will. Yes. Burnett Council for appellant prays 2 weeks times to furnish correct address to issue notice to respondent number 2. Office is directed to secure original records from the criminal. Is there? Interim order granted earlier is extended. Next date of hearing. The problem is today, I don't know, no advocates are there. I don't have any work. Therefore, I am asking all advocates to wait and I will decide that matter. Yes. What team?
My lord, I am for the appellant, my lord.
Yes.
My lord, this appeal is by the insurance company, BMTC.
Yes.
Challenging negligence and quantum of compensation.
Yes.
My lord, accident is between the motorcycle and the BMTC bus.
Yes.
My lord, the claimant is the rider of the motorcycle.
Yes.
Come on, the accident has taken place on my lord, 19/8/2017 at about 11:45 a.m.
Yes.
My lord, when the bus was moving near the airport road on Priya Bar and Restaurant, the rider of the motorcycle came with high speed in a rash and negligent manner in an attempt to overtake the bus on the left side, which is a very narrow place. My lord, he dashed against the left side middle body of the bus. Thereby, he fell down and sustained injury only to the hand fingers. only to the fingers. He has sustained injury. My lord, he is aged about 47 years and working as an electrician. My lord, earning some of rupees 15,000 per month. My lord, in this, my lord, though there was no negligence on the part of the driver of the bus, merely because it is a heavy vehicle, my lord, the police have filed a false criminal case against the driver of the bus. My lord, we have examined the driver. Driver has clearly stated that the rider of the motorcycle came from behind and in an attempt to overtake from the left side, he dashed against the left side middle body of the bus. Thereby, he fell down and sustained injury because of his own negligence, and he is not responsible for the accident. And police have filed a false criminal case. But except the evidence of the claimant, there is no evidence of any other independent eyewitness. My lord, tribunal, my lord, without considering this aspect, my lord, merely because the police have filed a false criminal case against the driver of the bus.
You read the finding of the tribunal.
Yes, my lord.
Regarding that negligence.
Yes, my lord. Para 11, my lord.
Yes.
Para 11.
Yes.
It is a specific case of the petitioner that on 19/8/2017 at about 11:45 a.m. when the petitioner was riding his scooter bearing registration number KS so on Old Airport Road, reached near Priya Bar and Restaurant. At that time, the driver of the BMTC bus bearing registration number so drove in a rational negligent manner, came at a high speed and dashed against the petitioner's motorcycle from behind. As a result, petitioner fell down and sustained grievous injuries. Hence, they pray for grant of compensation. In the written statement, the respondent has denied the rational negligent driving of the offending vehicle and has taken the contention that the accident has occurred due to the sole negligence of the petitioner. The petitioner K. Gurudev Reddy examined himself as PW1 and filed the affidavit in lieu of the examination. In his chief affidavit, he has stated the averments of the petition and further production of certified copies of the FIR merger marked as Exhibit P1 and P2, produce the copy of the sketch and IME report marked as Exhibit P3 and P4, produce the copy of the wound certificate and certificate copy of the charge sheet marked as Exhibit P5 and P6, produce 6 discharge summaries and 31 medical bills marked as Exhibit P7 to P13, produce 6 photographs with the CD and marked Exhibit P4, and produce a notarized copy of the RC card marked as Exhibit P15, and produce 1 certified copy of the complaint marked as Exhibit P16. In the cross-examination, the respondent counsel has specifically suggested that the accident was not occurred due to rash and negligent driving of the driving of the BMTC bus and due to his fault. The accident was occurred, but the same is denied. Nothing has been elicited but denial of accident. Another one witness, Dr. Naren has examined himself as PW2. In his chief affidavit, he has deposed, my lord, this is regarding medical aspect, my lord. Para 14, the respondent side, one witness, Rangraju, is the driver of the offending vehicle, examined himself as RW1 and filed affidavit in lieu of the examination chief. In his chief affidavit, he has deposed that the petitioner was riding the scooter on the left side of the road, left side of the bus, and in order to overtake from the left side of the bus, move towards the right of the moving bus, and the handle of the scooter touched the front left side wheel of the bus. As a result, the severe injuries on his hand. Hence, the accident did not occur due to the negligence of the driving of the bus, and the accident occurred solely due to the negligence of the petitioner, and further produced 1 notarized pre-pass marked as Exhibit R1. In the cross-examination, he is admitted that he has not filed any complaint against the petitioner, and also after the accident, the bus was seized by the police, and it admitted that the left side of the bus was damaged. And further, and after completion of the investigation, the IO has submitted the charge sheet against him, and the same has not challenged. I have perused the documents produced by the petitioner. It appears that the Indiranagar police have registered a criminal case in crime number so-and-so against the driver of the bearing number, bus number so-and-so. On the basis of the complaint lodged by the complaint, after submitting the FIR, the police have conducted the spot merger and prepared the sketch of the accident took place. sketch of the accident took place. After receiving the IME report and wound certificate and after completion of the investigation, IO has submitted the charge sheet against the driver of the offending bus for the offence punishable under section 279-338 of IPC. The police have alleged that when the petitioner was riding the motorcycle proceeding on the old airport road reached near Priya Bar Hotel, at that time the driver of the offending vehicle was drive the bus in a rash and negligent manner and came with a high speed and dashed against the petitioner motorcycle. As a result, the petitioner was fell down and sustained grievous injury. I have perused the measure and the rough sketch of the accident took place. It appears that the petitioner was proceeding on the two-wheeler on the left side of the road towards Halsur, and the offending bus was also proceeding towards Halsur on the right side of the petitioner's vehicle. And when they reached near Priya Bar, the bus driver has taken the bus towards left side and dashed against the motorcycle. Though the counsel for the respondent has argued that the accident occurred due to sole negligence of the petitioner, but in support of their contention, nothing has been elicited in the cross-examination of the petitioner. Further, the respondent have not denied the sketch and merger. Though the respondents have examined the driver of the offending vehicle, but he is admitting that they have not lodged complaint against the petitioner with regard to the accident was occurred due to the sole negligence of the petitioner. And also they have not challenged the complaint and the charge sheet. Hence, mere examination of the driver is not a ground to disbelieve the accident was occurred due to the rash and negligent driving of the offending vehicle. The respondents have denied the accident injuries sustained by the petitioner in the accident. After perusal of the IME report, it discloses that the left side portion of the front bumper of the BMTC bus was damaged and the right side sealed guard and silencer of the petitioner's vehicle was damaged. Therefore, it is clear that the offending bus came on the right side of
Yes, it is very clear. Yes. What else?
My lord, the filing of the criminal case against the driver of the bus, because it is, my lord, it's a heavy vehicle and government vehicle. Whenever, my lord, there is an accident between two vehicles.
Here there is no such finding because it is a heavy vehicle. The finding is based upon
the finding need not be because the vehicle involved in the accident is a heavy vehicle. Therefore, my lord, usually the police files a false criminal case against the driver of the bus. You will ask me kindly to see the sketch, my lord.
Yes.
The claimant is overtaking the bus in a narrow gap. There is no place at all on the left side of the road because he is in a hurry to move.
No, especially in this case, the court has taken into the consideration of the sketch as well as the IME report. Not on that there is no complaint has been on the basis that charge sheet has been not challenged. Here they have analyzed properly because you are saying that he is overtaking, but your bus has been damaged on left side.
One submission that has been denied by the driver, my lord. That question was put to the driver in the cross-examination. He says it is an old damage.
Under that circumstances, you have to see that records also. Record speaks.
Yes.
No, Allah, records has been seen by the tribunal. Record speaks that it is the left side of the bus has been damaged. If he is overtaking and if it is a damage on the right side of the bus, then your version is correct.
My lord, I know the result of
that. You made your attempt. No, you cannot consider this.
But to some extent, negligence can be fixed on the because he is overtaking. My lord, regarding this is more important regarding quantum of compensation, my lord.
Yes, we'll consider that your submission.
Yes, my lord. My lord, the quantum of compensation, you will ask me kindly see the wound certificate, my lord. Exhibit P5. Exhibit P5 says, my lord, that has been discussed in para 18 of the judgment. You will ask me kindly take up at para page 12 of the judgment, my lord.
Yes.
This is a very the injuries you will ask me kindly see.
Yes.
Injury to the right hand with a deglowing injury over the lower aspect with amputation of right finger at PP lower of F and A at DP level plus blunt injury. My lord, it is only the amputation of ring finger.
Yes. Yes.
It is only a simple amputation.
Yes.
My lord, the doctor, my lord, you ask me kindly see the evidence of Dr. My lord, how he has elaborated the evidence and has glorified the injuries and disability. My lord, with great respect to the doctor, my lord, the court should not encourage such type of evidence to be given.
Yes.
You ask me kindly see.
Well, he is not that regular doctor.
He is not a regular doctor, but he is becoming regular now.
Regular doctor, which I am seeing in that records,
Yes,
that is
yes.
not that record. There are some Prasad,
Yes,
some
yes.
other doctors.
ಹೌದೌದು ಸುಮಾರು ಜನ ಇದ್ದಾರೆ. ಸುಮಾರು ಜನ ಇದ್ದಾರೆ. ಅಲ್ಲ, ಇವರು ಈಗ ಹೊಸದಾಗಿ ಶುರುವಾಗಿದ್ದಾರೆ. You ask me kindly see.
Where is that?
Page 2 of his affidavit. Page 2 of his affidavit.
Bangalore, yes.
Page 2 of the affidavit.
Yes.
ಯಾವ ರೀತಿ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಯಾವ ರೀತಿ ಮಿಸ್ಲೆಡ್, they are taking they are abusing the process of law.
Yes.
78% disability na how he has explained under your last may kindly see, just for injury to the finger. This is how they are misleading the court to accept the evidence. With great respect, Malada.
He is a treated doctor.
He is not a treated doctor, but he says he has treated doctor.
But have you elicited in the cross-examination or produced any documents? Is not.
I'll come to that point, Malad. First, you'll ask me kindly see how he has assessed the disability.
Yes.
Page 2, Malad.
Yes.
In the middle portion, I have calculated his physical impairment for injury to the right hand as per Gazette of India guidelines and Gazette notification ಯಾವುದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. Next, arm component. ಇದರಲ್ಲಿ just for injury to the finger, lifting page 2.
Page 2, yes.
ಒಂದು ಇದ್ರ ತರ ಹಾಕೊಂಡಿದ್ದಾರೆ ಫಾಲೋಯಿಂಗ್ ಇಂಜುರೀಸ್.
Yes,
arm components ಅಂತ ಹೇಳಿ. You last may kindly see how he has assessed the disability. Lifting object overhead 5%.
Yes.
Touching nose.
Yes.
Eating Indian style.
Yes.
Combing and plating 9%.
Yes.
Eating Indian style 9%. Putting on a shirt 9%. Then ablution of glass of water 9%.
Yes.
Drinking glass of water 9%. Buttoning 9%. Tie the nada dhoti 9%. Writing 9%. What is this type of assessment of disability, my lord? How can they mislead the court and fool the court, my lord? And with great respect to him, he should not abuse the court process of law and confusing the court and giving this type of false evidence for a simple injury.
Court has taken that 98% disability.
ಅಲ್ಲ 30% to the whole body ತಗೊಂಡಿದ್ದಾರೆ, 78% ಲೆಕ್ಕ ಹಾಕೊಂಡು.
Is there any future prospects is added? No. ಕೊಟ್ಟಿದ್ದಾರಾ?
ಅಲ್ಲ, these are all coming in the way of his occupational income and whether he has referred to any of the disability with regard to the occupational income. ಬಟನ್ ಹಾಕಕ್ಕಾಗಲ್ಲ, ನೀರ್ ಕುಡಿಯಕ್ಕಾಗಲ್ಲ, ಕೈ ಎತ್ತಕ್ಕಾಗಲ್ಲ, ಲುಂಗಿ ಕಟ್ಟಕ್ಕಾಗಲ್ಲ, ಆಮೇಲೆ ಧೋತಿ ಕಟ್ಟಕ್ಕಾಗಲ್ಲ, ಮತ್ತೆ ಶರ್ಟ್ ಹಾಕಕ್ಕಾಗಲ್ಲ ಅಂದ್ರೆ ಜಿಸಿಕ್ ಎಲ್ಲರೂ.
Profession is an electrician.
Maybe, my lord, maybe. But he should give an evidence.
An expert. We can't dispute that. Unless...
No, my lord, we cannot go by his evidence merely because he is an expert. Whether he is telling truth or not is more important. Merely because whoever the expert says, his evidence cannot be taken as a gospel truth. Your last may kindly assess.
Cross examination.
Yes, please, my lord. ನಾನು ಅರ್ಜಿದಾರರಿಗೆ ಚಿಕಿತ್ಸೆ ನೀಡಿರುತ್ತೇನೆ. ಅರ್ಜಿದಾರರಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಆಸ್ಪತ್ರೆ ದಾಖಲೆಗಳನ್ನು ನೋಡಿ ಮತ್ತು ವೈಯಕ್ತಿಕ ಪರೀಕ್ಷೆ ನಡೆಸಿ ಅವರ ವೈಯಕ್ತಿಕ ಅಂಗನ್ಯೂನ್ಯತೆಯ ಪ್ರಮಾಣವನ್ನು ನಿರ್ಧರಿಸಿರುತ್ತೇನೆ. ನಮ್ಮ ಆಸ್ಪತ್ರೆಯ MLC ರಿಜಿಸ್ಟರ್ ಅನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುವುದಿಲ್ಲ. ಸಾಕ್ಷಿ ಸ್ವತಃ ರಿಜಿಸ್ಟರ್ನ ಪ್ರತಿಯನ್ನು ಒಳರೋಗಿ ದಾಖಲೆಯೊಂದಿಗೆ ಹಾಜರುಪಡಿಸಲಾಗುತ್ತದೆ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಮೂಲ ರಿಜಿಸ್ಟರ್ ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇರುವುದಿಲ್ಲ. ತೊಂದರೆ ಎಂದರೆ ಇರುವುದಿಲ್ಲ. MLC ರಿಜಿಸ್ಟರ್ ನಲ್ಲಿ ಅಪಘಾತಪಡಿಸಿದ ಬಸ್ಸಿನ ನಂಬರ್ ತಿಳಿಸಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಪೊಲೀಸ್ ಮಾಹಿತಿ ಸೋನ್ಸ ಇದು ರಿಗಾರ್ಡಿಂಗ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ my lord.
Para 2.
ಗಾಯದ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ನಾನು ವೈಯಕ್ತಿಕವಾಗಿ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ನಾನು ನನ್ನ ಸಾಕ್ಷ್ಯದ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಅರ್ಜಿದಾರರ ಬಲಗೈಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಚಲನವಲಯ ಕುರಿತಂತೆ ಮತ್ತು ನ್ಯೂನತೆ ಕುರಿತಂತೆ 78% ಕೊಟ್ಟಿರುವುದು ಸರಿ. It is not percent to the right finger at all. My lord, as per WC Act, my lord, your last may kindly say for loss of one finger, my lord, 3 to 7%. 3 to 7%. How we can say 78%, my lord? Is he not misleading the court, my lord?
Yes.
Then, my lord, ಅದು ಅರ್ಜಿದಾರರಿಗೆ ಸಹಾಯ ಮಾಡಲು ಹೆಚ್ಚಿನ ಪ್ರಮಾಣವನ್ನು ತೋರಿಸುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಅರ್ಜಿದಾರರ ನಿರ್ದಿಷ್ಟ ಅಂಗನೂತನೆಯನ್ನು ಕುರಿತಂತೆ ಕೊಟ್ಟಿರುವ ಪ್ರಮಾಣದಲ್ಲಿ ಇಡೀ ದೇಹಕ್ಕೆ 3/1 ಪ್ರಮಾಣದಷ್ಟು ಮಾತ್ರ ಪರಿಗಣಿಸಬೇಕಾಗುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿ ಆ ರೀತಿ ನಾನು ಪರಿಗಣಿಸುತ್ತೇನೆ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರಿಗೆ ಆದ ಗಾಯವು ಶಾಶ್ವತ ಅಂಗನ್ಯೂನತೆ ಆಗಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅರ್ಜಿದಾರರಿಗೆ ಆದ ಮೂಳೆ ಮುರಿತವು ಸರಿಯಾಗಿ ವಾಸಿಯಾಗದೇ ಇರುವುದು ನಮ್ಮ ವೈದ್ಯಕೀಯ ನಿರ್ಲಕ್ಷ್ಯತೆ ಕಾರಣ ಆಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅರ್ಜಿದಾರರು ಮುಂದುವರೆದ ಚಿಕಿತ್ಸೆ ಪಡೆದುಕೊಳ್ಳಬೇಕಾಗುತ್ತದೆ ಎನ್ನುವ ಕುರಿತಂತೆ ನಾನು ದಾಖಲೆ ಹಾಜರುಪಡಿಸುವುದಿಲ್ಲ. ಫಾರ್ ರಿಗಾರ್ಡಿಂಗ್ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್, ನಾನು ಮುಂದುವರೆದ ಚಿಕಿತ್ಸೆಗಾಗಿ 2 ಲಕ್ಷ ಬೇಕಾಗುತ್ತದೆ ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತೇನೆ. 2 ಲಕ್ಷ ರೂಪಾಯಿ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್, ಮೈ ಲಾರ್ಡ್. ಅಲ್ಲ, ಈಸ್ ಇಟ್ ದ ವೇ ಆಫ್ ಗಿವಿಂಗ್ ಎವಿಡೆನ್ಸ್ ಬೈ ಅ ಡಾಕ್ಟರ್, ಮೈ ಲಾರ್ಡ್? ವಿ ಕಾಲ್ ಹಿಮ್ ಆಸ್ ಅನ್ ಎಕ್ಸ್ಪರ್ಟ್. ಕೃತಕ ಅಂಗೈಯನ್ನು ಜೋಡಿಸಲು 50,000 ಅಗತ್ಯ ಅವಶ್ಯಕತೆ ಇರುತ್ತೆ ಅಂತ ಸುಳ್ಳು. ಒಂದು ಬೆರಳು ಹೋದ್ರೆ ಇಡೀ ಒಂದು ಕೈನೇ ಆರ್ಟಿಫಿಷಿಯಲ್ ಹ್ಯಾಂಡ್ ಹಾಕ್ಬೇಕಾಗತ್ತಾ? ದಿಸ್ ಇಸ್ ಹೌ ಈಸ್ ಗಿವಿಂಗ್ ಎವಿಡೆನ್ಸ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಆನ್ ಓತ್, ಮೈ ಲಾರ್ಡ್. ಆಸ್ಪತ್ರೆಯಿಂದ ಬಿಡುಗಡೆ ಆಗುವಾಗ ಅರ್ಜಿದಾರರು ಆರೋಗ್ಯವಾಗಿದ್ದರು ಎಂದರೆ ಸರಿ. ಈಸ್ ಪರ್ಫೆಕ್ಟ್ಲಿ ಆಲ್ ರೈಟ್. ಅಂಗನ್ಯೂನತೆಯನ್ನು ನಿರ್ಧರಿಸುವ ಸಮಯದಲ್ಲಿ ಅರ್ಜಿದಾರರಿಗೆ ಆಗಿದ್ದ ಗಾಯಗಳು ವಾಸಿಯಾಗಿದ್ದವು. ಆಲ್ ಇಂಜುರೀಸ್ ಆರ್ wounds are healed, he admits. ಅರ್ಜಿದಾರರಿಗೆ ಮುಂದುವರೆದ ಚಿಕಿತ್ಸೆ ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. My lord, the accident has taken place in 2017. Now we are in 2022. My lord, if there is any further medical future medical expenses required, by this time they could have produced before the court. That they have not done. ಅರ್ಜಿದಾರರಿಗೆ ಮುಂದುವರೆದ ಚಿಕಿತ್ಸೆ ಅವಶ್ಯಕತೆ ಇರುತ್ತದೆ ಎಂದು ನಾನು ಸಾಕ್ಷ್ಯದ ಪ್ರಮಾಣದಲ್ಲಿ ತಿಳಿಸುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಫಿಸಿಯೋಥೆರಪಿ ಮಾಡುವುದರಿಂದ ಅರ್ಜಿದಾರರ ಕೈಗಳ ಮಾಂಸಖಂಡಗಳು ಉತ್ತಮ ಬೆಳವಣಿಗೆ ಕಂಡು ಬರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ನಾನು ಅರ್ಜಿದಾರರಿಗೆ ಸರಿಯಾಗಿ ಪರೀಕ್ಷೆ ನಡೆಸದೆ ಮತ್ತು ಅವರ ಆಸ್ಪತ್ರೆ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸದೆ ಅಂಗನ್ಯೂನತೆ ಪ್ರಮಾಣವನ್ನು ತಿಳಿಸಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸುಮಾರು 10 ಬಾರಿ ನನ್ನ ಹತ್ತಿರ ಚಿಕಿತ್ಸೆಗಾಗಿ ಬಂದಿರ್ತಾರೆ. ಅರ್ಜಿದಾರರಿಗೆ ಸಹಾಯ ಮಾಡಲು ಹೆಚ್ಚಿನ ಪ್ರಮಾಣದ ದೈಹಿಕ ನ್ಯೂನತೆ ತೋರಿಸಿ ಸುಳ್ಳು ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸಿ ಸುಳ್ಳು ಸಾಕ್ಷ್ಯ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. My lord, whatever may be the cross-examination, my lord, whatever may be the examination, chief, your lordship will have to go by what is the type of injury and what is the disability. And as per WC Act, my lord, it is only 3 to 7% disability for loss of one finger.
Yes.
He says 78% to the limb and the tribunal has taken 30% to the whole body.
Yes.
And my lord, regarding future medical expenses, my lord, 50,000 is awarded. Well, injuries are healed, complete. Where is the question of further medical expenses, my lord?
Yes.
And in the document it shows no operation is conducted as per discharge summary. At the time of discharge, he was perfectly all right. Therefore, my lord, regarding future loss of income, my lord, tribunal has not gone into the documents properly and not applied its mind and simply believed on the false and fabricated evidence of the doctor, my lord. Tribunal has awarded, my lord, huge compensation of rupees 5 lakh. My lord.
61,000.
Yes, my lord. Just for finger, my lord.
Yes.
It is very much on the higher side. But the future medical expenses 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Then you last may kindly see, my lord, how the tribunal has awarded pain and suffering ಒಂದು finger fracture 60,000 plus towards future medical expenses 1 ಲಕ್ಷ, loss of immunity 75,000. ಏನ್ ದುಡ್ಡಿಗೆ ಏನು ಬೆಲೆನೇ ಇಲ್ಲ, my lord. ಅಲ್ಲ, with great respect I am telling, my lord, this is how the case has been dealt. Very exorbitant compensation, my lord.
Yes.
Total 9,43,633 with 9% interest. With 9% interest. Very much on the higher side. It has to be drastically reduced in all aspects.
Yes.
Particularly the evidence of the Dr. Mallard, we cannot go by his evidence. He has given totally inconsistent, irrelevant evidence that is in no way concerned with the injury and also occupational income. ಎಲ್ಲದಕ್ಕೂ 99% ಬಟನ್ ಹಾಕಕ್ಕಾಗಲ್ಲ, ಇದಕ್ಕೆ ಹಾಕಲ್ಲ, ಅದಕ್ಕೆ ಹಾಕಲ್ಲ ಅಂತ ಕೊಟ್ಟರೆ ವಾಟ್ ಇಸ್ ದಿಸ್ Mallard?
What is that injury?
Exhibit P5 is the wound certificate that is discussed at Mallard, para 18, Mallard, para 18 at page 12.
To the right with deloading injury over the lower aspect. Amputation of the right RP and PP lower F. Then the right RP antra right finger.
Right finger. Right finger.
Right ring finger of yes.
Right ring finger.
Yes. Yes. What is your yes. What is the income you have claimed? 1,000 rupees per day. Signal has taken? Yes. 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 Days of inpatient is 43 days. He has taken treatment for 6 months. Hospitalization for 43 days.
ಅಲ್ಲ ಅಷ್ಟು ದಿವಸ ಬೇಕಾಗಿಲ್ಲ ರಿಂಗ್ ಇಂಜುರಿ ಟು ದ ಫಿಂಗರ್ಗೆ.
ಅವ್ರು ಕಂಪ್ಲೀಟ್ ಆಗ್ಲಿ ವೈಟ್. Yes. Incidental expenses incidental 22,000. Yes. What is the date? From which date to which date you said? 19/8/17. Yes. Actually, overall, yes, Mr. Vijay Kumar. What is your reply?
Mallard, for an injury to the right hand, Mallard. Mallard, 25,000 rupees is toward 22,000 towards the transportation of food or nourishment added charges.
Yes.
Mallard, on all heads, Mallard, the tribunal has granted heavy compensation. I leave it to your lordship. But the BMTC is running under loss. And for all these simple injuries, Mallard, if they pay in lakhs, Mallard, where the public money should go. Your lordship will have to safeguard the public money. That is my submission.
That's all. Shri P. Vijay Kumar, Learned Counsel appearing for corporation has submitted that the accident is occurred due to the rash and negligent driving of claimant himself. He tried to overtake the bus and dashed to the right side of the bus and fell down.
Left side of the bus. Left side of the bus.
He tried to overtake from the left side of the bus. Left side of the bus. And the handle of the motorcycle has touched to the bus and he fell down. He sustained injury. The corporation has examined the driver as RW1. In his evidence, he has categorically stated that the claimant was riding his scooter in the left side of the bus, and in order to overtake the left side of the bus, moved towards right side of moving bus, and handle of the scooter has touched the front side left wheel of the bus. As a result, he sustained injury. The tribunal has failed to consider the evidence of the driver of the bus. He further contended that it is very clear from the sketch, Mazur, and IME report that accident is occurred due to the negligence of claimant himself. Tribunal only on the ground that the driver of the bus has not lodged any complaint and he has not challenged the charge sheet filed against him, as held he is negligent in causing that accident. In respect of compensation is concerned, he has contended that the injury suffered by the claimant is only in respect of the right hand middle finger. The injuries are not in grievous in nature. The disabilities assessed by Dr. Naren PW2 is on higher side. Tribunal failed to consider that wound certificate exhibit P5 as only on the basis of the evidence of the doctor has assessed that whole body disabilities is 30% is on higher side. He further contended that the injuries suffered by the claimants are minor in nature.
My lord, as per Schedule 2 of the Workman Compensation Act,
yes.
May I read, my lord?
Yes.
Ring finger or little finger, my lord, whole 7%.
Yes.
2 from next 6%.
Yeah, even as per Workman Compensation Act,
if the whole finger is amputated, 6%,
amputation
7%.
of the finger, it cannot be more than 7 to 10% disability.
7% only.
Yes. The tribunal has error in assessing whole body disabilities is 30%. He further contended that the injuries suffered by the claimants are minor in nature. He has suffered only injury to his middle finger. It will not affect his day-to-day activities. The compensation awarded by the tribunal, pain and suffering and loss of immunities is on higher side. Even though he was inpatient only for 43 days.
Actually 35 days ಆಗುತ್ತೆ calculation ಪ್ರಕಾರ.
The doctor, without any the supporting materials, has deposed that he requires 2 lakhs rupees for future medical expenses. Even the claimant has not produced any documents that he has incurred any amount for future medical expenses. Therefore, the future medical expenses awarded by the tribunal, 1 lakh, is on higher side. Lastly, he has contended that in view of judgment of this court in so and so, the interest awarded by the tribunal 9% is on higher side. Hence, he sought for allowing that appeal. Per contra, Sri Gurudev Prasad, learned counsel appearing for the claimant, has contended that the accident is occurred due to the negligence of driver of the offending vehicle. He was driving that bus in rash and negligent manner, tried to overtake the bus and dashed to the right side of the motorcycle. Due to that impact, the claimant has fell down and sustained injury. He further contended that it is very clear from the IM report that left side portions of the front bumper of the PMTC bus was damaged, and also right side shield guard silencer of the petitioner vehicle was damaged. It is also very clear from the sketch that driver of the bus was trying to overtake that motorcycle and the scooter dashed against the scooter. Even evidence of PW1 is very clear that the accident is occurred due to the negligence of driver of the bus. Immediately after, the claimant has lodged a complaint against the driver of the bus. The police has registered an FIR, and after thorough investigation, they have filed a charge sheet against the driver of the bus. So far, the charge sheet has not been challenged by the driver of the bus. Tribunal, considering the evidence of the parties and material available on record, has rightly held that driver of the bus is negligent in causing the accident. In respect of quantum, he has contended that at the time of the accident, the claimant was earning 12,000. Estimating claimant 1,000 per day as a electrician. The tribunal has considered the notional income of the claimant as 12,000 is on lower side. He further contended that since due to that accident, the claimant has suffered grievous injury. He has suffered injury to his hand. Since he was an electrician, he requires his work by using that hand. Due to that injury, he was unable to do his day-to-day work. Considering that injury suffered by the claimant and considering that evidence of doctor and wound certificate exhibit P5, the tribunal is justifying assessing whole body disabilities is 30%. He further contended that due to the accident, the claimant has suffered grievous injury. He was inpatient for a period of 43 days and he has taken a treatment for 6 months from 19/8/2017 to 20/2/2018. And he has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Under those circumstances, throughout his life. Therefore, the tribunal is justifying granting a compensation for pain and suffering, loss of immunities, and other incidental expenses. The tribunal has failed to grant any compensation for loss of income during the later period. Hence, she is contended that considering that injury suffered by the claimant and his age and avocation, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Third, the learned counsel for the parties peruse judgment and award. It is not in dispute. It is the case of the claimant that on 19/8/2017, at about 11:45 a.m., when petitioner was riding his scooter bearing registration number KA01 HR8639, proceeding on Old Airport Road, Bangalore City, carefully after following the traffic rules. At that time, PMTC bus bearing registration number KA01 FA1529, driven by driver in rash and negligent manner so as to endanger the human life, came in high speed and dashed against the petitioner's scooter from behind. As a result, he fell down and sustained injury. Immediately, he was shifted to St. John's Hospital. After recovering from the injury, he has filed a claim petition. To prove his case, the claimant himself has examined as PW1 and he has examined the doctor Naren as PW2 and he has marked 19 documents. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 19/8/2017. And it is also not in dispute that the offending vehicle was involved in the accident. Offending bus was involved in the accident. In respect of the negligence, categorically stated that the accident is occurred due to the negligence of driver of the bus and he has deposed that when he was riding his motorcycle on left side of the road, the driver of the bus came behind in rash and negligent manner and while overtaking that scooter, his left side of the bus has touched to that scooter and he fell down. Immediately after, he has been shifted to St. John's Hospital and he has lodged the complaint against the driver of the offending vehicle. As per the FIR has been registered as per Exhibit P1. The respondent, the claimant PW1 has been cross-examined by the respondent, has suggested that the accident is occurred due to the rash and negligent, not due to the rash and negligent driving of driver of the bus. The said suggestion has been denied by the claimant, except that nothing has been elicited from the evidence of the petitioner. Nothing worthwhile has been elicited in the cross-examination of PW1. To disprove the versions of the claimant, the respondent has examined Rangaraju, driver of the bus, has RW1. In his deposition, he has deposed that the rider of the scooter was riding the same on left side of the bus, and in order to overtake the left side of the bus, move towards the right side of moving the bus and handle of the scooter, touch the front side of the left wheel of the bus. As a result, he fell down and sustained injury. In his cross-examination, he has admitted that he has not filed any complaint against the petitioner, and he has admitted that the bus was seized by the police. And he is also admitted that left side of the bus was damaged. And he is not disputed that there is a charge sheet filed against him, and he has not challenged the same. The police, after registering the complaint, has drawn a sketch spot mazo as exhibit P2, and exhibit P3 is the spot sketch. And IME report has been produced as exhibit P4. It is very clear from the above said documents, the petitioner was proceeding on his two-wheeler on the left side of the road toward Halsur, and the offending vehicle bus was also proceeding towards the Halsur on the right side of the petitioner vehicle. When they reached near the Priya bar, the bus driver has taken the bus towards left side and dashed to the petitioner motorcycle. Even as per that IME report, it is disclosed that left side portion of the front bumper of the BMTC bus was damaged, and right side shield guard and silencer of the petitioner vehicle was damaged. Therefore, it is very clear that the driver of the bus was coming on right side of the petitioner's vehicle and dashed the right side of the petitioner vehicle. Hence, it is clear that due to the rash and negligent driving of the offending vehicle, the accident was occurred. The tribunal, after perusing the FIR exhibit P1, spot major exhibit P2, spot sketch exhibit P3, and wound certificate exhibit P5, and IME report exhibit P4, has rightly come to the conclusion that the accident is occurred due to the rash and negligent driving of driver of the bus. Yes, you can. In respect of quantum is concerned, even though the claimant has claimed that he was earning 1,000 per month, 1,000 per day, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, the notional income has to be considered as 11,000. Due to that accident, the claimant has suffered the following injury. He has examined the doctor, Dr. Naren as PW2. In his evidence, he has deposed that the claimant has suffered total limb disabilities is 98%. Considering that evidence of doctor, considering that wound certificate, and we suffered by the claimant, I am of the opinion that the whole body disabilities can be assessed 25%. At the time of the accident, deceased was aged about 47 years. The multiplier applicable to the age group is 13. 13. Accordingly, yes, loss of future earnings has been reassessed as follows. Due to that accident, the claimant has suffered the above said injury. He was inpatient for a period of 43 days. He has taken treatment for 6 months from 19/8/2017 to 20/2/2018, and he has suffered a lot of pain during the treatment. He has to suffer the disability and unhappiness throughout his life. Considering that evidence of Dr. Naveen PW2 and wound certificate exhibit T5, I am of the opinion that the claimant is entitled, the compensation awarded by the tribunal for pain and suffering has to be reduced to 50,000 from 60,000. Loss of amenities has to be reduced to 50,000 from 75,000. And the claimant is entitled loss of income during the later period for 5 months. In respect of future medical expenses is concerned, the claimant has examined the doctor. Doctor has deposed that the claimant has required 2 lakhs for future medical expenses. The claimant has not produced any document to establish the same, or he has not produced any document that he has incurred any, he has undergone any surgery or incurred any amount for future medical expenses. Under that circumstances, considering that evidence of the doctor and injury suffered by the claimant, the future medical expenses awarded by the tribunal has to be reduced 50,000 from 1 lakh. The compensation awarded by the tribunal, on the other hand, are just and reasonable. In view of judgment of this court, the interest awarded by the tribunal has to be reduced to 6% from 9%. Accordingly, the appeal is allowed in. Have you deposited the entire amount?
My lord, we have deposited, my lord, I think 50% of the.
Yes.
50% of the award amount, my lord.
Yes. Amount in deposit is transferred to tribunal. Delay maridiya.
Future loss of income ಎಷ್ಟು ಬಂತು ಅಂತ ಗೊತ್ತಾಗಲಿಲ್ಲ.
Future loss of income ಎಷ್ಟು ಬಂತು? 4 lakh. Yes.
4 lakh mana?
4,29,000 ಬಂದಿದೆ ಸರ್.
Yes, madam.
ಬಂದಿದ್ದಾರೆ ನೋಡಿ ಸರ್ ಮಾಧವಸ್ವಾಮಿ ಅವರು.
ಬಂದಿದ್ದಾರೆ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ ಸರ್. ಇದು ಅದೇ ಸರ್ ನೀವು ಹೇಳಿದ ಮಾಸ್ಟರ್ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಕವರ್ ಆಗುತ್ತೆ. ಡಿಸಬಿಲಿಟಿ 10% ಗಿಂತ ಕೆಳಗೆ ತೋರಿಸಿರ್ ಸರ್. ಹೋಲ್ ಬಾಡಿ ಡಿಸಬಿಲಿಟಿ 10% ಅಂತ ಹೇಳಿದೆ, ಅದನ್ನೇ ತಗೊಂಡಿದೆ. ಆಸ್ ಪರ್ ದಿ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಕೇಸಲ್ಲಿ 10% ಇದ್ರೆ ಮಾತ್ರ ರಿಲ್ಯಾಕ್ಸ್. ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ, ಎಲ್ಲಾ ಹೆಡ್ ಅಲ್ಲೂ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes, Mr. Madhavaswamy, what is that? 16 ವರ್ಷ. 16 years ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರು? ಮತ್ತೆ ನಾನ್ ಅರ್ನಿಂಗ್ ಮೆಂಬರ್ ಎಷ್ಟಿದೆ? ಯಾವ್ದ್ರದ್ದು ಇದು? ಕಾಜಲ್. It has to be taken as that notional income. 18 multiplier ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? ಅಲ್ಲ, ಇಲ್ಲಿ ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರು ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಇನ್ಕಮ್?
4,000 ತಗೊಂಡಿದ್ದಾರೆ ಸರ್ ಪರ್ ಮಂತ್.
What is the date of the accident? 2015
sir. 2015.
The Supreme Court said you take 5,000 for this thing. Kajal case ಅಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿದ್ದಾರೆ? is a case of injury.
ಹೌದು ಸರ್.
This is also case of injury. ಅಲ್ಲ ಇದದ್ದು ಕಾಜಲ್ ಕೇಸ್ ಅಲ್ಲಿ injury case. Which is the paragraph? Both the court below that since the girl was young child 12 years only, national income per annum can be taken into consideration. ಆಯ್ತು ಎಷ್ಟು ಬರುತ್ತೆ? What is the date of the accident? 9,000. 10%. 18. Where is that? Tara? Yes. Yes. The functional impairment of 29% disability with respect to the limb. The PWD is treated petitioner. Where is that doctor? Which doctor? He is a neurologist. Yes. What are the injuries? Permanent physical with regarding to the loss of future income. Where is that discussion regarding the doctors? PW1 doctor who has treated the petitioner. Hemorrhage. Yes. Doctor ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ? 29%. Yes.
Functional disability.
Now, what is that 3,42,000 medical bill you have produced? Loss of income during the period of rest, 50,000. Pain and suffering, 50. Was loss of future income. Yes. Loss of immunity is 40 kodi. Injury, pain and suffering. Yes, only in respect of future medical nil towards amenities ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of future earning has to be reassessed. ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರವಲ್ಲ?
ಹೌದು ಸರ್.
What is that interest awarded? 6%. Yes, madam. What you said?
ಸ್ವಾಮಿ ಇದೆಲ್ಲ ಎಕ್ಸಾಮ್ ಎಲ್ಲ ಬರ್ದಿದ್ದಾರೆ, ಸ್ಕೋರ್ ಮಾಡಿದ್ದಾರೆ ಅಂತೆಲ್ಲ ಎಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಡಿಸಾಬಿಲಿಟಿ 10% ತಗೊಂಡ್ರೆ ಸರಿ ಇದೆ ಸ್ವಾಮಿ. ಅವರು ಮಾಡಿರೋದು. ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಎಕ್ಸಾಮ್ ಎಲ್ಲ ಬರ್ದಿರ she has scored 474 marks ಅಂತರ ಹೇಳಿ.
Yes, after that you have
ಇದರಲ್ಲಿ 1 ಲಕ್ಷ
no, but disability is affected your future.
ಇಲ್ಲ ಸರ್, ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೇಳಿದ್ದಾರೆ. ಪರೀಕ್ಷೆಯಲ್ಲಿ 474 ಅಂಕಗಳನ್ನು ಪಡೆದಿರುತ್ತಾರೆ ಎಂದರೆ ಇರಬಹುದು, ಗಾಯಗಳಿಗೆ ಸ್ಮರಣಶಕ್ತಿ ಕುಂದಿಲ್ಲ, ಮೊದಲಂತೆ ಕೆಲಸ
What
ಮಾಡಬಹುದು.
is the case of this Kajal? Whether what is the percentage it is assessed here, Mr.?
ಇಲ್ಲಿ
Of the
ಪರ್ಟಿಕ್ಯುಲರ್
below so and so forth can be taken into consideration as assessing the future into this single study. Each case has to be decided on its own evidence, taking the national income are payable to the state workers. Our opinion, this would be the minimum amount which should have been earned. Adding particular reservations to applying that. That's all. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲ ನೀವು ಆಮೇಲೆ ಎಕ್ಸಾಮಿಗೆ ಹೋಗಿದ್ದಾರೆ ಎಕ್ಸಾಮ್ ಬರ್ತಿದ್ರು ಅಲ್ಲಪ್ಪ ನೀವು ಅವಾಗ ಎಕ್ಸಾಮಿಗೆ ಹೋಗಿಲ್ಲ then there is no loss of any academic year, is it not? Academic year is not lost. You are not lost the academic year. That is what that ಏನಾರು ಲಾಸ್ ಆಗಿದ್ರೆ ಮಾತ್ರ ತಾನೇ ಕಾಂಪನ್ಸೇಟ್ ಮಾಡೋದು ಅಷ್ಟೇ. there is no actual ಆಗಿ ಅಕಾಡೆಮಿಕ್ ಇಯರ್ ಏನ್ ಲಾಸ್ ಆಗಿಲ್ಲ. ಎಸ್ ತಗೊಳ್ಳಿ. ಕನ್ವೆನ್ಷನಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಕೊಟ್ಟಿದಾರಲ್ಲ Income during the later period 50,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲಿ you are not this. Yes. No, that injury is very grievous. ಮತ್ತೆ ನೀವು ಏನೋ ಅದನ್ನ ಬರೀ ಬೆರಳಿಗೆ ಒಂದು ಕಾದ್ರೂ ಇಂಜುರಿನೇ. ಮತ್ತೆ you cannot say that. Only thing is principle is that income na you can take it that notional income ಅನ್ನೋದನ್ನ assess. But all this it's all depending upon the each injury. Yes. Sri Madhe Swami Learned Council appearing for climate has contended that at the time of the accident she was aged about she was aged about 12 years. She was studying in SSLC. 16 years she was studying in SSLC. Due to that accident she has suffered grievous head injury. She was unable to continue her studies and it affects her studies since she was a very bright student. She has a good academic records. Yes. ಮತ್ತು ಒಂದು ವರ್ಷ ಆದ್ಮೇಲೆ ಎಕ್ಸಾಮಿಗೆ ಅಟೆಂಡ್ ಆಗೋದು. Have you produced any documents? Mass card already, mass card pass ಆಗಿರೋದು. See, ನೀವು ಆ ವರ್ಷ SSLC ಇದ್ರಿ, ಈ ವರ್ಷ ಎಕ್ಸಾಮ್ ಆಯ್ತು, ಆ ವರ್ಷ ಆಗ್ಲಿಲ್ಲ, ನಾನು ಸಪ್ಲಿಮೆಂಟರಿ ಮಾಡಿದ್ದೆ ಅನ್ನೋದಕ್ಕೆ ಏನಿದೆ ದಾಖಲಾತಿ? ಎಲ್ಲಿ have you stated that? Where is that evidence? Evidence ಅಲ್ಲಿ ಹೇಳಿದಿರೇನ್ರಿ ನೀವು? ಕೊಡಿ ಹೌದು ಎವಿಡೆನ್ಸ್. She was SSLC held at accident due to the grievous injuries around head, chest, and back. She was unable to pursue her studies properly and could not be attended the SSLC exam. She lost the abilities of the life. Only 1 year last ಅಂತ ಹೇಳದೇ ಇಲ್ಲ ನಾನು. ಎಲ್ಲಿ ಹೇಳ್ತೀರಾ? ನಾನು ಅದನ್ನೇ ಓದಿದ್ದು. Unable to prosecute, concentrate their studies properly, could not attend her SSLC examination. She lost the amenities of the life. Cannot attend the SSLC due to the accident. Education was greatly affected and she was unable to concentrate her studies. Education education has been great. No, can't attend her SSLC examination. Yes, where is that SSLC marks card? ಅಪಘಾತ ನಂತರ 6 ತಿಂಗಳು exhibit.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಹೇಳಿದಾರೆ ಸ್ವಾಮಿ, SLC ಬರೋದು ಪಾಸ್ ಆಗಿದ್ದಾಳೆ.
ಯಾವಾಗ ಅಂತ ಯಾವಾಗ ಏಪ್ರಿಲ್ 2016
ಯಾವಾಗ ಅಂತ ಹೇಳಿ SLC ಬರೆದು ಪಾಸ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ವೆದರ್ ಶಿ ಹಸ್ 474 ಮಾರ್ಕ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತಾನು ಹೇಳ್ತಾರೆ ಸರ್. ಅಂಕಪಟ್ಟಿ ಜೆರಾಕ್ಸ್ ಪ್ರತಿ ಪ್ರಕಾರ
2015 ಅಲ್ಲಿ she has lost SSLC exam.
ಯಾವಾಗ ಎಕ್ಸಾಮ್ ಬರದ್ಲು ಅಂತ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿಲ್ಲ ಸಮಯ.
ಇದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ has been produced. 2016 ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಎಕ್ಸಾಮ್ ಇನ್ ಬರ್ತಿದ್ದಾರೆ.
ಸೊ ಜನವರಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು. ಎಕ್ಸಾಮ್ ಆಗುತ್ತೆ 16 ಇದಕ್ಕೆ ಆ 15 ನಲ್ಲಿ ವೆದರ್ ಶಿ ವಾಸ್ 9th ಸ್ಟ್ಯಾಂಡರ್ಡ್ 10th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಅಂತ ಎಲ್ಲೂ ಏನು ಹಾಕ್ಲಿಲ್ಲ ಅವರು. ಅಕಾಡೆಮಿಕ್ ಇಯರ್ ಯಾವ ವರ್ಷದಲ್ಲಿ ಏನ್ ಓದ್ತಾ ಇದ್ವು ಅಂತ ಹೇಳಿ. ಜನವರಿ 2015 ನಲ್ಲಿ
ಏನಿದೆ ವಾಟ್ ಇಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಸೆಡ್ ದಟ್ ಆನ್ 2015 you were an SSLC student.
ಇಲ್ಲ ಶಿ ವಾಸ್ ಸ್ಟಡಿಂಗ್ 15 ನಲ್ಲಿ SLC ಓದ್ತಾ ಇದ್ಲು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಸರ್.
ಏನಿದೆ
ಸ್ಕೂಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಾದ್ರು ಒಂದು ಹಾಕಿ.
ಎಲ್ಲ ಐತ್ರಿ ಇದ್ರಲ್ಲಿ 2015 SSLC ಅಂತ.
ಇಲ್ಲ ಸರ್
2015 ಅಲ್ಲಿ 9th ಐತ್ರ.
ಹಾ ಅದನ್ನೇ ಹೇಳಿ ಸರ್.
ಏನಾರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಪ್ಪ ನೀವು ಸುಮ್ಮನೆ ಅದನ್ನ ಹೇಳ್ಬೇಡ. ಎಲ್ಲಾರು ಇದ್ರೆ ಅದ್ರಲ್ಲಿ ಇರೋದನ್ನ ತೋರ್ಸೋದ್ ಬಿಟ್ಟು ಸುಮ್ಮನೆ ಇಟ್ ಇಸ್ ಕೋರ್ಟ್ ಮಿಸ್ಟರ್. ಏನದು ಅದೇ ಎಲ್ಲಿದೆ ಎಕ್ಸಿಬಿಟ್? ಮಾಸ್ ಕಾರ್ಡ್ ಎಷ್ಟು ಯಾವ್ದು ಎಕ್ಸಿಬಿಟ್? 14 ಏನಿದು? ಸೆಂಟ್ ಮೇರೀಸ್ 10th ಕ್ಲಾಸ್ ಅಲ್ಲ, ಏನು ಇಯರ್ ಯಾವ್ದಿದು? 2000. ಸರಿ 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 ಅದೇ ದಟ್ಸ್ ವಾಟ್ ದಟ್ ಯು ಹ್ಯಾವ್ ಟು ಸಿ. ರೆಕಾರ್ಡ್ಸ್ ಇರುತ್ತೆ, ನೋಡೋದಿಲ್ಲ ಏನಿಲ್ಲ, ಸುಮ್ಮನೆ ನಾವು ಓದ್ತಾ ಇದ್ದೀವಿ. 2014 ಜುಲೈಯಲ್ಲಿ ನೀವು ಹ್ಯಾವ್ ಪೇಡ್ ಫೀಸ್ ಫಾರ್ 10th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಅಂತ ಅಂದ್ರೆ 2014 and 15 you are an SSLC students. ಅವತ್ತು ಅದನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತೋರಿಸ್ಬೇಕು. Yes madam, on 2014 and 15 she is an SSLC student. There is a document. Yes. Third. So and so learned counsel appearing for the claimant has contended that at the time of the accident she was studying in SSLC. at the ಹಾಕೊಂಡು ಬರ್ತಾರಲ್ಲ ಹೇಳಿದ್ದೆ ಅಲ್ಲ ಕಂಟೆನ್ಷನ್ CHN studies. Yes. She has examined the doctor. Doctor has assessed the disability is 29%. Since injury suffered by the claimants is an head injury, the neurological surgeon has rightly assessed the disability suffered by the claimant is 29%. The tribunal is error in considering that whole body disabilities is 10%. He further contended that even though claimant is a student, she has a very good future. The loss of income has to be assessed considering the notional income. In support of his contention, he has relied on judgment of Apex Court in case of Kajal versus Jagdish Chand and others, reported in 2020 SC 776. He further contended that due to that extent, the claimant has suffered grievous injury. She was unable to continue her study. She has lost one academic year and she has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout her life. The compensation awarded by the tribunal, pain and suffering, loss of amenities is on lower side. The tribunal has, and she was inpatient for a period of 40 days. ಎಷ್ಟು ದಿನ ನಿಮ್ದ್ರಲ್ಲಿ?
40 days.
How many days?
40 days.
ಅಲ್ರಿ ಹಾಸ್ಪಿಟಲ್ ಎಷ್ಟು ದಿನ ಇದ್ರಿ ಅಂತ?
40 days.
Yes, inpatient for a 40 days. that the tribunal, the compensation awarded by the tribunal for pain and suffering, loss of immunities is on lower side. The tribunal has not granted any compensation for ಕೊಟ್ಟಿದಾರಲ್ರಿ nourishment expenses.
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ 55,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
The compensation awarded with the tribunal. ಎಲ್ಲಿದೆ ಮೆಡಿಕಲ್ ಬಿಲ್?
ಇದೆ ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ 3 ಲಕ್ಷ ನಾನು ಜಾಸ್ತಿ.
The tribunal has not granted any compensation for attendance charges. You are there in that, you have taken an attender for taking care. Yes. Not granted any compensation for attendance charges since she has suffered a head injury. She has been taken care of by that attender. Lastly, he has contended that for contra, so and so learned counsel appearing for she lastly has contended that due to that injury, there is a disfigurement. The tribunal has not granted any compensation for marriage prospects. Hence, he sought for enhancement of compensation. For contra, so and so learned counsel appearing for, is it corporation? Corporation, yes. Even though the claimant has contended that the claimant has examined the doctor. Doctor has assessed the disabilities is 29%. Considering that injury suffered by the claimant and considering her age, the tribunal has justified in assessing the whole body disabilities is 10%. She further contended that there is no loss of academic year since the claimant has appeared in examination in the year 2017. She has passed in the SSLC. 2016. She has passed in the SSLC.
2016 passed.
And she has continued her service. Therefore,
education.
The tribunal has rightly not granted any compensation for future loss of income. She further contended that considering her age and injury suffered by the claimant and considering that evidence of doctor, the overall compensation awarded by the tribunal is just and reasonable. Hence, she sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 21/1/2015 due to rash and negligent driving of driver of the bus bearing registration number KA57F878. Due to that accident, the claimant has suffered the following injury. She has examined the doctor, Vinayak Kadlamatti. In his evidence, he has deposed that the claimant has suffered 29% disability in respect, suffered 29% disability. Since injury suffered by the claimant is a head injury, considering that evidence of the doctor and considering that wound certificate, I am of the opinion that the whole body disabilities has to be assessed 15%. The apex court, in case of Kajal Supra, has held that even in case of minor who are students, their notional income has to be assessed as per notional income has to be assessed as per the salary of the skilled workman. Hence, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority for the accident occurring 2015. The notional income has to be considered. 9,000.
Accident date 25/1/15.
Yes, 9,000. The multiplier has to be considered as 18. Accordingly, loss of future earning has been reassessed as follows. Yes. Due to the extent, the claimant has suffered grievous injury. He has inpatient for a period of 40 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. Loss of income during the later period ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ 50,000. ಎಷ್ಟು ಇದು ನಾವು ಮಾಡಿದ್ವಿ 9,000 ಅಲ್ಲ 45,40 ಕರೆಕ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Pain and suffering ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ 50,000. I'm of the opinion that the claimant is entitled loss of immunities for 50,000 and attendance food and attendance charges has to be granted for 15,000 and claimant is entitled 30,000 for marriage prospects. Entitled 50,000 for marriage prospect and loss of one academic year. Accordingly, ಏನ್ ಲಾಸ್ ಆಗಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಅವ್ರು ಪಾಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಲ್ಲ, ಎಲ್ಲ ಟ್ಯೂಷನ್ಗೆಲ್ಲ
ರಸೀಟ್ ಅದು ಸ್ಕೂಲ್ಗೆಲ್ಲ ಕಟ್ಟಿರೋದು, ಕೋಚಿಂಗ್ ಸೆಂಟರ್ ಕಟ್ಟಿರೋದು.
Therefore, that 3 lakhs rupees for future medical ಆಯ್ತು, ಇದಕ್ಕೆ ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಅರ್ನಿಂಗ್ ಕೊಟ್ಟಿರೋದು. ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಅರ್ನಿಂಗ್ ಅಂದ್ರೆ ಥ್ರೂಔಟ್ ಇನ್ ಫ್ಯೂಚರ್ ಅಲ್ಲಿ ನಿಮಗೆ ಲಾಸ್ ಆಗುತ್ತೆ ಅಂತ, ಬಟ್ ದೇರ್ ಇಸ್ ನೋ ಡಿಸಬಿಲಿಟಿ ಫಾರ್ ಹರ್. ಬಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಸೆಡ್, ಬಿಕಾಸ್ ಆ ಕೇಸಲ್ಲಿ ಯಾಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅಂದ್ರೆ ಫ್ಯೂಚರ್ ಅಲ್ಲೇ ಅವಳಿಗೆ ಡಿಸಬಿಲಿಟೀಸ್ ಇರುತ್ತೆ, ನಿಮಗೆ ಅದಿಲ್ಲ. ಹಂಗಾಗಿ ಆ ಕನ್ಸಿಡರೇಷನ್ ದಟ್ ಐ ಹ್ಯಾವ್ ಸೆಡ್ ಯು ಆರ್ ನಾಟ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ಅದರ್ ಹೆಡ್. ಎಸ್, ಜಾಸ್ತಿ ಆಯ್ತು. 3 lakhs we have granted under that head for ಅಲ್ಲ 3 lakhs we are granted 2 lakhs and 90,000 for future medical ಅಲ್ಲ, ಇದು loss of future earning. Future earning I will distinguish this matter and I will reassess. It will come less than that because it is not that entire future that disability. Second thing, ಲಾಸ್ ಆಫ್ ಅಕಾಡೆಮಿಕ್ ಇಯರ್ ಎಲ್ಲ ಹೋಗಿರೋದ್ರಿಂದ ಸೇರ್ಸ್ಬಿಟ್ಟು ಅದರಲ್ಲೇ ನಾನು ಬಿಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ. ಮಿಸ್ಟರ್ ಮಾದೇಸ್ವಾಮಿ, the compensation awarded and under that head is 1.5 lakhs rupees higher because loss of academic year ಇರೋದ್ರಿಂದ ಸುಮ್ಮನೆ ಆಗಿದ್ದೀನಿ. Otherwise, even that Mallikarjun case has to be considered, ನಿಮಗೆ ಅಷ್ಟೇ ಬರುತ್ತೆ. Below 10 years ನಿಮ್ದು ಅಂದ್ರೆ ನಾನ್ ಅರ್ನಿಂಗ್ ಮೆಂಬರ್. ಇದರಲ್ಲಿ why they have to take in a notional income and calculate, because in the future also it has affected. ನಿಮ್ದು ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಎಕ್ಸಾಮ್ ಬರ್ದು ನೀವು ಪಾಸ್ ಆಗಿದ್ದೀರಾ, that means to say head injury has not affected your future. ಡಾಕ್ಟರ್ ಅಲ್ಲ, ನೀವು ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಎಕ್ಸಾಮ್ ಬರ್ದಿದ್ದೀರಾ ಅಂದ್ರೆ she has all right, but she has scored 400 marks.
474 marks.
Yes. If you want to argue, I can distinguish everything and I can reduce also. I can say all these things.
In fact, ಕಡಿಮೆ
taking consideration of all these aspects, since he is a student,
ಸೇರಿಸಿ
we are granting some liberal.
1 ಲಕ್ಷ ಕೊಡ್ಬೇಕಿತ್ತು ಸರ್ ಅಂತದ್ರಲ್ಲಿ.
Yes. ನನ್ನ peer ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು. Connect ಮಾಡಿರೋ ನಾಟು TB. Who has filed? ನೀವು ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ? You are appearing for climate. ಅದೇ ನಿಮ್ದು ಅಪೀಲ್. ಅದೇ ರೀ climate has filed an appeal ಅಂದ್ರೆ ನಿಮ್ದು ಅಪೀಲ್. ಅದು before the division bench. Learned counsel for the climate has submitted that the climate has filed an appeal challenging the very judgment and award in MFA so and so. The same is pending before the division bench. In view of the above, hence the office is directed to post this matter along with the so and so before that division bench having a roster after obtaining necessary order from the chief justice.